Ray Morales on behalf of the state. Your Honor, Mr. Gonzalez is still in Hillsborough County.
All right, thank you. All right, Mr. Gonzalez is housed in Hillsborough County Jail. I believe that we've tried to have him transported by way of a transport order. Has not been successful based on the delays in transportation based on COVID. We're going to reset Mr. Gonzalez's case for about 30 days out.
And Your Honor, I was able to verify that you have a hold for Osceola, but just to be safe, would you like me to just submit an updated transport order?
Yeah, we'll try it again.
All right. I do know that they have a couple cases going on out there, and most recently the disposition got reset to tomorrow, actually. So that might have been another reason. Okay.
Let's do a transport order for Wednesday, March 3rd at 8:30.
I'll get that to your chambers today. So.
Thank you very much. And that's on both of his cases, 2018 CF 1717 and 2018 CF 1736.
Yes, sir.
Come back to we'll come back to Mr. Larue's case. Denzel Lawrence.
Good morning.
Good morning.
Ebony Cobb on behalf of Mr. Lawrence. He is in custody at this point.
The state.
I'd like to go ahead and enter a plea of not guilty. Judge, I'd like to set this for a competency status. I filed a motion that defense has reasonable grounds that Mr. Lawrence is incompetent to proceed. Dr. Duros is scheduled to evaluate Mr. Lawrence at the jail. And so I believe the next hearing would need to be a competency status hearing.
All right.
What day is the state inquires what day the evaluation at the jail is?
One moment, Dr. Duros, normally she does them from her office. I don't have the information with me now, but I can send it to you by email.
And if she's doing it from her office, will that be via Zoom or Teams?
It is through IC Solutions with the jail.
Okay, is there a way for the state to attend virtually? And I'm sorry, Judge, that we're having a conversation. Your Honor, the state inquires of the defense whether there's a way for the state to virtually attend the evaluation at the jail.
You can go to the jail.
All right, I think the state's got a right to be present at the evaluation. I'm going to let you guys sort out the details of how that's going to occur. Mr. Baird, if you need some court intervention on those discussions, you'll need to set that before the court.
Yes, sir.
All right, Mr. Lawrence, your attorney has entered a plea of not guilty on your behalf and is working on your case. There's going to be some documents have already been filed on your behalf. I believe a doctor is going to come out and talk to you on video, and we're going to set this for a status hearing, competency status. What do you think? 30 days out, Ms. Cobb?
That's fine, Judge.
All right, thanks. We'll set this on March 10th at 8:30. 3/10/8:30.
And sir, like I said before, once I get that date in stone, I'll make sure I'll coordinate with the state attorney.
Thank you, Ms. Cobb. All right, thank you, sir. All right, the next case that I have is 2018 CF 2458 LeBron Rivera. We've received a waiver of Mr. LeBron Rivera's appearance for arraignment. Do we have Mr. LeBron Rivera? No? Okay. We've already given this one new dates, I think.
It's been set for VOP status 2/17 and VOP hearing of April 1st.
All right, thank you. Sandra Moulton.
Nicole DePree on behalf of Mr. Moulton.
Thank you. Good morning. Good morning, Ms. Moulton. Ms. Moulton, I'm looking at the charging document in your case, which is the information in 2020 CF 3732. It alleges one count of petty theft with 2 prior theft convictions for something alleged to have happened on December 27th, 2020. Mr. Collins, is there an offer of resolution on this one?
There is, Your Honor. There's a global offer. We had another case, I think, last week, and you signed a transport orders, or not transport, a transfer request. This is how we got this case. The global would be plea is charged to both cases. That's for 20 CF 3708 and 20 CF 3732. 7 months in the Austin County Jail, court costs, cost of prosecution, and no return to the location.
All right. Thank you. Madam Assistant Public Defender, what's your position?
At this time, we'd enter a not guilty plea, Your Honor.
Thank you. Ms. Moulton, your attorney has entered a plea of not guilty on your behalf. She'll be coming out to talk to you about that offer of resolution to see whether that's acceptable to you or not. If it is, or some version of that offer is acceptable to you, she can get you back before the court. Otherwise, we're going to give you a pretrial and a trial date.
Pretrial of April 28th, trial date of May 10th.
Thank you, Ms. Moulton.
Thank you.
Your Honor, just briefly before you call the next case, I do have a plea date at 9 o'clock with Ms. Vickers. I do have to run, I guess, upstairs to Judge Young for a brief 9:15 and 9:30 hearing. So then I'll come back for that plea. I do anticipate a victim being present on Teams.
Okay,
So I
do you
don't
want
know.
me to do it now?
If Ms. Vickers is there, I wasn't sure if she was
She's
gonna be-
present. Who is the alleged victim?
The victim is Miss Bisnothi.
I do not see anybody by that name in the Teams meeting.
I can double check with her, Your Honor, but I think we can move forward we can at least start the plea.
All right, thanks.
I didn't want to interrupt the arraignment docket. I just wanted to let the court know
No,
where I was going
I'll
to be.
try and get you on your way if it's a resolution, and Ms. Vickers is waiting. Ms. Vickers, can you hear us?
Yes, Your Honor.
All right, good morning. We have, the Assistant State Attorney is present here in open court, Mr. Mers, and the defendant's name, please.
Michael Phillips,
All right,
he has two cases, one with Ms. Vickers and one with Mr. Johnson from the Public Defender's.
all right, thank you. Do we have Mr. Phillips present? Good morning, sir. Mr. Phillips, we're going to place you under oath.
Please raise your right hand. Thank you. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. All right, I've got two cases, 2020 CF 2982 and 2020 CF 3596. I do not have a
I have
plea form in front of me.
the plea form for Ms. Vickers' case.
All right, thank you. I do have a plea form in front of me. That was previously filed, and Mr. Mers, is there a score sheet?
Yes, Your Honor. I provided this morning to the clerk the cost of investigation order as well as the score sheet and restitution order.
All right, thank you. I see Ms. Bishnoth has now joined us.
I think you gave me Navarros.
There should have been a score, everything was paperclipped together on Phillips.
I've got Mr. Phillips's,
Okay.
Mr. Phillips's document. Ms. Bishnoth, can you hear us?
Yes, sir.
All right, thank you. Ms. Bishnoth, we have called Mr. Phillips's two cases, 2020 CF 2982 and 2020 CF 3596. And you're welcome to observe. Mr. Mers is present here with me in court, as well as Ms. Vickers, who represents Mr. Phillips. Mr. Phillips is at the jail facility and has been sworn in. Mr. Phillips, I have been provided with two plea forms, one for 2020 CF 2982, one for 2020 CF 3596. Each of them appears to have been initialed by you after each of the 26 paragraphs, as well as signed over the word defendant. Did you have an opportunity to read and understand these documents?
Yes, Your Honor.
What your signature and your initials tell me on these documents is that you have had enough time with Ms. Vickers to go over these resolutions and you understand all the rights and obligations on the plea form. Is that correct?
Yes, Your Honor.
Your Honor, if I can just interject, I represent Mr. Phillips on 2020 CF 2982, and Mr. Johnson represents Mr. Phillips on the other case.
All right,
So
thank you.
we both independently have gone over the plea forms with him.
For the respective cases, yeah.
Got it. All right, thanks. So you heard that representation. You've had a chance with both of your attorneys to talk about your cases and understand the plea forms, correct?
Yes, Your Honor.
In 2020 CF 3596, this document indicates to the court that you wish to plead no contest to counts 1 and 3. Count 1 being tampering with a witness to hinder communication to a law enforcement officer. That's a third-degree felony allegation. And count 3, violation of a pretrial release condition, and that is a first-degree misdemeanor. Is that what you wish to do?
Yes, Your Honor.
And in 2020 CF 2982, the document indicates that you wish to plead no contest to 1 count of battery domestic violence related and count 2 grand theft, count 1 being a first-degree misdemeanor and count 2 being a third-degree felony. Is that what you wish to do?
Yes, Your Honor.
Do you understand that the third-degree felony allegations are each punishable by up to 5 years in prison each, 5 years supervised probation each, or a $5,000 fine each? The first-degree misdemeanor allegations are punishable by up to 1 year in the county jail, 1 year of supervised probation, or a $1,000 fine each. Do you understand those are the maximum sentences for each type of charge?
Yes, Your Honor.
Do you understand as to both cases you have a right to have a jury trial? And at the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you had committed the offenses that you were charged with. At that trial, your attorneys would have been with you. They would have cross-examined witnesses and examined evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, could ask me to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision after you talked things over with Ms. Vickers and Mr. Johnson, and your juries would have been instructed not to consider that decision to remain silent in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. Do you understand you are giving up all of your trial rights because if I resolve both of these cases, I'm going to do it in a way that is written on your plea forms, and we are not going to be having a trial as to either case. Do you understand that?
Yes, Your Honor.
Is anyone forcing you or pressuring you into making this decision?
No, Your Honor.
Has anyone made you any promises other than what is written on your plea forms?
No, Your Honor.
Are you under the influence of any alcohol, any drugs, or any mental issues that cause you not to understand the decision that you're making?
No, Your Honor.
Do you understand if you are not a United States citizen, entry of these pleas would subject you to deportation?
Yes, Your Honor.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of these pleas could subject you to involuntary civil commitment. Do you understand that?
Yes, Your Honor.
Ms. Vickers, in your case, is the defense stipulating to a factual basis for acceptance of the plea?
Yes, Judge.
Thank you. And Mr. Johnson, in your case, is the defense stipulating to a factual basis for acceptance of the plea?
Yes, Judge.
Mr. Merce, does Ms. Bishnoth wish to give any statements prior to sentencing?
Your Honor, I know previously she was thinking about it, so if I may, Ms. Bishnoff, if you can hear me, did you wish to provide a statement to the judge this morning?
Ms. Bishnoth, did you hear the Assistant State Attorney?
No, sir.
You don't wish to give a statement, is that correct?
Yes, sir.
Okay.
Thank you, Judge.
All right. Thank you. Right. Mr. Phillips, based on our discussions, you appear to be alert and intelligent. You've had an opportunity to think about this decision and discuss this decision with each of your attorneys. Are you satisfied with Ms. Vickers' help on her case?
Yes, Your Honor.
And are you satisfied with Mr. Johnson's help on that case?
Yes, Your Honor.
Court is going to adjudicate you guilty in 2020 CF 2982 of count 1 and count 2. As to count 1, you're sentenced to 90 days in the Osceola County Jail. You'll get credit for the time that you have already served in your case,
62 days.
which is 62 days on that case.
I have 68 days. He had, he had 10 days from October 12th to October 21st, and then the bond was revoked on December 15th to today.
Was he in custody when the bond was revoked?
Yes.
Are we on, which case are we on?
We're on 2020 CF 2982.
I'm sorry, I have 63 days. It's just a 1 day difference.
Okay. And the calculations are from what dates?
I have from 10/20 to 10/21, he gained 2 days, bonded out, received an FTA. It was recalled and his bond was revoked on 12/12, up until today, the credit is 63 days. Here you go.
Yeah, Ms. Vickers, we're showing between 10/20 and 10/21 is 2 days, and from 12/12 to 2/3 was 54 days, and from 2/4 to 2/10 is another 7 days. So we're showing.
I'm showing that he was arrested on October 12th and released on October 21st.
It was a warrant case, Your Honor. The 12th is the date of the incident. But I have that he was arrested on 10/20.
Yeah, it was a warrant case. Incident date was 10/12, arrest date was 10/20.
Okay.
All right, so that's going to give him 63 days of credit for time served on that case. If you find out after the fact that that's incorrect, Ms. Vickers, you can petition the court for additional time.
And Your Honor, I do believe you said that he was being adjudicated guilty on both counts. Count 2 is a withhold of adjudication.
My apology, okay. Count 1 in 2020 CF 2982 is an adjudication. As to count 2, the adjudication will be withheld. The sanction for that, he'll get credit for the 63 days that he has already served. He will be placed on 4 years and 9 months of probation. As a condition of probation, he's going to complete the batter's intervention program. It needs to be signed up and successfully completed within the first 12 months of probation. He'll be randomly tested for any drugs in his system. He is agreeing to restitution the amount of $8,000, a cost of investigation the amount of $114. There's going to be a court costs in this case.
And Your Honor, there should also be no contact with the victim.
Okay. That didn't make the score sheet. Didn't make the plea forms. Was that, Ms. Vickers, was that a condition of probation that he have no contact with Ms. Bischoff?
Yes, I'm sorry, that is.
All right, thank you. As a condition of probation, you were to have no contact whatsoever with Ms. Bischoff. That means directly or through any third party or electronically. Do you understand, Mr. Phillips?
Yes, sir.
Madam Clerk?
I'm sorry, was there a substance abuse evaluation?
No, that got removed.
Thank you, sorry. Court costs of $413, a battery surcharge of $201, $100 cost of investigation, for a total of, $714.
Right, you owe
I didn't hear that.
$713.
Thank you.
You're going to owe $713 on that case, Mr. Phillips. That will be paid off second. Any payments that you make first will go to restitution first. You'll have the entire period of probation to make payments towards restitution and court costs. I am looking, Mr. Mers, I don't know if I've got a restitution order for Ms. Bischoff on 2020 CF 2982. I have one for 3596.
It was attached. I filled it out.
Got a ton of paperwork. No, I've got it. Thanks. All right, that's going to do it for 2020 CF 2982. As to that case, you have 30 days from today's date to appeal the judgment sent to the court. If you wish to do so, you must do it in writing. If you can't afford an attorney, one will be appointed for you. In 20,
Your Honor,
yes.
Sorry, just to finish up that case, it was to be concurrent with 2020 CF 3596, and that probation can be transferred to either Georgia or New York.
All right, I have no objection to you transferring your probation to your home state. You'll need to report to probation within 24 hours of your eventual release and begin that transfer process. And that is approved either to Georgia or New York. It will run concurrently, meaning at the same time with the sentence I'm about to announce in 2020 CF 3596. On that one, anything further, Ms. Vickers?
And just that count 1 and 2 are concurrent to each other.
Okay, all counts are concurrent, and the sentence to run concurrent with 2020 CF 3596. In 2020 CF 3596.
And
Court-
Judge, I don't mean to butt in real quick. I just want to clarify. There was one issue on my plea form. Since we turned in the plea form last week, we're dropping the substance abuse evaluation and treatment. I'd just be asking if we could scratch that out on the plea form. I wasn't able to run up at this point to get that scratched out.
All right, thank you. I've scratched through that document. Is that correct, Mr. Mers? Mr. Mers?
That is correct, Your Honor. In exchange for the agreement to the restitution, the state did agree to remove that from both sentences.
All right, I have scratched through that particular requirement and put my initials by it.
Thank you, Judge. I apologize.
Mr. Phillips, the court will withhold adjudication as to count 1, tampering with a witness to hinder communication to a law enforcement officer. You will be adjudicated as to count 3. As to count 1, you'll be sentenced to 90 days in the Osceola County Jail. We're showing credit for 62 days on 2020 CF 3596. That's to be followed by 4 years and 9 months of supervised probation with the same conditions as previously announced in your other case. Those are you will complete the batterer's intervention program within 12 months successfully. You'll have no contact with the victim. You'll be randomly tested for any drugs in your system. A standard condition is that you are not to possess any weapons or firearms. As to count 2, you'll be adjudicated guilty, sentenced to 90 days in the Osceola County Jail. Get credit for the 62 days that you have already served. These counts are to run concurrent with each other, and the sentence previously announced. State is to count 2.
Yes, Your Honor. The state would announce a null pros to count 2 battery domestic violence in this case.
Thank you. Are we ordering restitution reserving to amount as to 2020 CF 3596?
There's no restitution being sought as to that specific case number, Your Honor.
Thank you. All right, there's going to be court costs on this case as well, Mr. Phillips.
I'm sorry, so it's count 3,
Counts 1 and 3.
and count 2 is being moved.
Correct.
Okay. Court costs of $413, $100 cost of prosecution, $100 PD lien for a total of $613.
You have $613 on that case, Mr. Phillips. That will be made a condition of your 4 years and 9 months of probation. As to that case, I have no objection to you transferring your probation to your home state, and you'll need to check into probation within 24 hours of your eventual release. You'll have 30 days from today's date to appeal the judgment and sentence to the court. If you wish to do so, you must do it in writing. Can't afford an attorney, won't be appointed for you. Mr. Johnson, anything further on this case?
I don't believe so, Your Honor.
Thanks. Mr. Mers, anything further?
Nothing further, Your Honor.
All right. Thank you. That's going to complete our sentencing hearing. Good luck to you, Mr. Phillips. Thank you for joining us, Ms. Bishnoth, and good luck to you as well.
Thank you. Thank you for taking that out of turn, Your Honor. I appreciate it.
All right, back to our arraignment docket. Thank you for your patience. Is Justin Ortiz present?
Should be, Your Honor.
Morning, Mr. Ortiz.
Good morning, sir.
Nicole DePrey on behalf of Mr. Ortiz.
Mr. Ortiz is here on a status hearing on, does he just have the one case? Yeah, 1262. Mr. Prey, what's the status on Mr. Ortiz?
Your Honor, Mr. Ortiz has an offer to resolve his case. He signed a plea in Lake County, and it's a concurrent offer. I just want to see if we can set it for the next available video date. He just got here, and I just want to make sure that his credit time served is clear. He was revoked, or at his initial appearance, he had an ROR. But the state is willing to stipulate to the time because he's been in custody since May. I just want to make sure I have the exact timing to tell him so that he's sure on the exact time he'll have left in custody. So if we could just set it to the next plea date.
All right, the next date that I have, the jail feed is 2/17 at 8:30.
That's perfect.
Who's the state?
Good morning, Your Honor. Amanda Cassie on behalf of the state. That's acceptable with the state.
All right, thank you. Mr. Ortiz, we'll see you back in 1 week from today at 8:30 to resolve your case.
Yes, sir.
Thank you.
You're welcome.
Timothy Price.
Alex Johnson on behalf of Mr. Price.
Morning,
Your
Mr.
Honor.
Price.
Before we swear him in, looking at the case, this was upfiled from a misdemeanor case. There was a notice of incompetency filed in that case. So at this time, I wasn't comfortable with doing an arraignment on Mr. Price based on that. There was an issue. I was going to be asking if we could set this for a competency status to address the motions that were filed in the lower court. But I was asking if we could set that out because the issue is that the latest report from Dr. Davis, which is the only report that's not stale, doesn't address state hospital in the report due to it originally being a misdemeanor charge. And I was following up with the doctor to see if we could make a simple amendment as to that.
State.
Your Honor, the state doesn't take a position at this time. Would like to see the requirements. I did notice that myself when I reviewed all the prior assessments. I made note, and then I also need to talk to the victim in this case. I didn't have an offer.
All right, so Mr. Johnson, your plan is to contact Dr. Duros and see if you can get that amendment, or Dr. Davis?
Dr. Davis, because Davis is the only one whose report is still within the past 6 months.
All right, thanks. How far of a reset are you requesting, Mr. Johnson?
If we could do 2 weeks, because this should be a fairly simple amendment. I don't think we have to go through another evaluation. It's just changing a sentence on the report, basically.
Let's recall Mr. Price's case on March 3rd at 8:30.
Thank you, Judge.
All right, thanks. All right. All right, we've got somebody here. I anticipate there's some clothing that has been brought from Mr. Tott. I'm not anticipating Mr. Tott being brought over to the courthouse.
Yeah, that's correct. I spoke with Hafner,
Mm-hmm.
and she advised that being transported.
Yeah, we weren't anticipating transporting Mr. Tott. We were going to have Mr. Tott appear by video. I'll discuss that with the attorneys, and if they want to reset and have him physically present, we're going to have to do that sometime after the 15th. Thanks. Roderick Smith.
Alex Johnson on behalf of Mr. Smith. Sorry.
Amanda Cassie on behalf of the state, Your Honor.
Thank you. Good morning, Mr. Smith.
Good morning.
Mr. Smith, I'm holding an information in your case in 2020 CF 2579 alleges 1 count of trafficking in 4 grams or more of fentanyl. That is a first-degree felony allegation that carries with it a proposed 3-year minimum mandatory sentence for something alleged to have happened on October 28th, 2019. Mr. Johnson?
Yes, Your Honor. At this time, defense will be entering a plea of not guilty. We did receive an offer from the state, which I was able to convey to Mr. Smith this morning. He just needs to talk it over. If we want to resolve that early, I'll get him into court sooner than pre-trial.
All right, thanks. Mr. Smith, you are already represented by the Office of the Public Defender, Mr. Johnson. He's aware of an offer that he wants an opportunity to talk over with you. We're going to put you on a pretrial and trial date.
Pretrial of March 24th, trial date of April 5th.
And if you and Mr. Johnson reach a resolution with the state that's acceptable to you, he can get you back before the court before then.
Yes, sir.
All right, thanks. Thaddeus Williams.
Nicole DePree on behalf of Mr. Williams.
Morning,
Just
Mr. Williams.
Sorry, Your Honor.
In 2021 CF 113, I'm holding the information, which is the charging document. Mr. Williams, it alleges 3 counts. Count 1 is possession of ULOAN. Count 2 is possession of drug paraphernalia, and count 3 is petty theft. Count 1 being a third-degree felony allegation, count 2 being a first-degree misdemeanor allegation, and count 3 being a second-degree misdemeanor allegation for something alleged to have happened on January 9th, 2021. You're represented by the Office of the Public Defender. Mr. Prey?
Yes, Your Honor. We would inquire with the state if there's an offer to resolve.
There is. The offer would be on count 1, adjudication of guilt, 24 months of drug offender probation, 100 hours of community service, no return to the Walmart, life skills class, court cost, cost of prosecution, and then counts 2 and 3, adjudication, credit time served.
Mr. Prey?
We'd enter not guilty at this time.
All right, thanks. Mr. Williams, the state has given your attorney an offer to resolve your case. He wants an opportunity to talk that over with you. Mr. Prey, do you want me to set this for anything other than a pretrial and trial date?
No, Your Honor. I will speak to Mr. Williams, and if he would like to accept the offer, I'll set a date with your JA.
All right, thanks. Mr. Williams, I can address your case if there's some offer of resolution that's acceptable to you as early as next Wednesday at 8:30. Mr. Prey will talk to you about what your options are. We're going to give you a pretrial and trial date at this point.
Pretrial of April 28th, trial date of May 10th.
We'll accept that plea of not guilty. Thank you, Mr. Williams. Arsenio Woodard.
He's been waived already and set for April 28th and May 10th.
All right, thank you. Liang Wu Fontalvo.
Also waived, set for VOP status February 17th, VOP hearing April 1st.
Thank you. Got one more case on our 8:30 docket, and that is Gregory Larue. Do we have Mr. Larue out in the hallway?
Minutes on behalf of Mr. Larue. Your Honor, I went upstairs just to verify if Mr. Larue was there. He was not.
All right, thank you. I'll note for the record, it's now 9:30. We're going to call the hallways for Mr. Larue, and I'm going to pull him up. I'm checking the email correspondence. We have not gotten any correspondence that Mr. Larue was denied entry into the courthouse based on the COVID protocols.
Your Honor, is there an option for resetting Mr. Larue? He wants to take the offer from the state. It has been at his intention since the beginning. It may have been a confusion on Mr. Larue's side.
Well, let me take a look at the docket and see. All right, there was a notice of date to the bondsman for, looks like pretrial on the 13th. Let me see if there was any additional. Yeah, Mr. Larue was present in court when we handed him his status hearing date for today's date at 8:30. And
Your Honor, based on that is my request. Mr. Larue has never failed to appear to our court, and I'm asking if the court can reset his plea date certain.
appears that he was out on bond when he picked up this new. No, I'm sorry, he was out on bond.
So got multiple failures to appear on his score sheet. I'm looking at it. I apologize, I had to pull it up.
Yeah.
2000 failure to appear, 2002 failure to appear, 2006 failure to appear, 2007 failure to appear, and a bunch of violations of probation.
All right. Court's going to issue a warrant for Mr. Larue. We've called the hallways, and Mr. Larue is not present. He was provided valid notice in 2020 CF 2501. He was present when we set the date. Based on the representation that there are prior failures to appear, the court's going to find a waiver of speedy trial 2020 CF 2501, issue a warrant for his arrest. Bond will be set in the amount of $5,000. Ms. Jimenez, if you can get him in here ASAP, we can revisit the issue of bond.
Sorry, Your Honor.
Yes, Your Honor. Thank you.
What's that?
Yes, 4 counts.
So it's going to be $2,500 is to count 1, and $500 is to count 2, 3. No, I'm sorry, that doesn't. The math doesn't work. $1,000 is to count 2. $1,000 is to count 3, and $500 is to count 4.
Thank you.
All right, moving on to our 8:45 docket. Roberto Michaels. Thank you.
Nicole Dupree on behalf of Mr. Michaels.
Thank you.
Just on behalf of the state, Your Honor.
Judge, this case is a mental health status update. Mr. Michaels was initially rejected from mental health court due to them missing some information from him. We were able to get that information, and we've resubmitted his application to mental health court, so we're just waiting for them.
Good morning, Mr. Michaels.
Morning, sir.
Mr. Michaels, I'm looking at Mr. Prey, your attorney, on my computer screen, as well as the state. I understand that you're being considered for one of our alternate court systems, and they are waiting on some paperwork. Mr. Prey, all of that paperwork has now been transmitted, is that correct?
Yeah, I believe it was done either yesterday or the day before. Mental health court just needed an evaluation. They said that they would consider him if that was done. It was submitted through social services, so we're just awaiting for them, their response.
Understood. Mr. Collins, position on a reset?
No objection, Your Honor. This is something also the victim was actually talked to me about, and we think this is a great channel for this case to pursue.
All right, thanks. 30 days enough, do you think, Mr. Prey?
I believe so, Your Honor.
Thank you. Right. Thank you for coming into court, Mr. Michaels.
Yes, sir.
I'm going to set your status hearing for March 10th. That's a month from now at 8:30. If you have been accepted into the mental health court, you will not need to be present, and your attorney can give you that information. If not, come on in on the 10th, and I'm going to see if I can sort out what, if anything, I can do to expedite this process.
Yes, sir.
So right now, I'll give you a new status date, 3/10 at 8:30. Stay in contact with Ms. Dupre, and if she tells you that you don't need to be here, that's because it appears that you've been accepted into the mental health court.
Yes, sir.
All right, thank you very much, sir.
Thank you, sir.
Have a seat outside, I'll bring you the paperwork.
Yes, sir. Thank you.
All right, I'm going to take Mr. Mullins real quick. Good morning, Mr. Mullins. Can you hear me?
Yes, Your Honor. Can you hear me? I just unmuted my mic.
Yes, sir. I can hear you just fine. Which case are you here on?
I'm here on, there's a review here on Mr. Wolfelder.
Thank you.
Mental health.
Yes, sir. That's 2017 CF 336. Is Mr. Timothy, do we have a Mr. Wolfelder present?
Mr. Wolfelder's in state hospital. He's not present in the courtroom.
I wrote that note. Thank you. So Mr. Wolfelder is still in Appalachia Center. Our last review correspondence from them was on November 16th. Has anyone got any more updated information about Mr. Wolfelder?
Benjamin Baird for the state. I have not.
I have a document dated January 15th, 2021, Your Honor. It's a monthly progress report. It's issued by Haley O'Brien, who's a forensic case manager up there at Appalachia Center. and she's got it marked into 5 different. Let me see here, 6 different categories. She with the summaries being everything being favorable.
All right, thanks. Is the recommendation that he continue with treatment?
I'm sorry, Your Honor, I didn't hear that.
Is the recommendation that he continue with the program and treatment?
Yes, yes, Your Honor, and that it looks like they're going to move him down to the next building, which is Gadsden Residential.
Right. Would you have your staff be so kind as to file that in our court file? I think you've got the only status update, Mr. Mullins.
Yeah, if I'd have known that, Judge, I'd have filed it earlier. I'm sorry. I'll make sure that gets done today.
Mr. Baird, I'm inclined to set this off for about 6 months. Any reason to set it earlier than that?
No, Your Honor, that seems, reading the previously entered order setting today's hearing, that certainly seems like the appropriate action here. Yeah, 6 months seems appropriate just to make sure that he's still in compliance and still following recommended treatment.
All right. We'll set a competency status date on Thursday, October.
I think it's an NGI status date, Your Honor.
An NGI status date on Thursday, August 12th at 8:30.
August 12th at 8:30, Your Honor?
Yes, sir.
Okay, got it. I'll go ahead and get this monthly progress report for January filed today.
Thank you very much, Mr. Mullins.
Okay, thank you, Your Honor. That's all I have.
All right, have a good day.
Have a good day.
All right, the next case that I have is Donald Draper. Corrections, do we have Mr. Draper?
No, sir, he's not on our list.
Okay, I think Mr. Draper is still apparently in Volusia County. Does anybody have any information to the contrary?
Nicole Dupre on behalf of Mr. Draper. Yeah, he's still in Volusia County on new charges there.
Okay. Shall we try again in 30 days?
That's fine with me.
Your Honor, Amanda Cassie covering on behalf of ASA Peter Donnelly. Yes, he was just hoping for an arraignment date and no bond as of today without a bond hearing, so.
All right, well, Mr. Draper's not present, and I'm not sure there's much I can do about it. I'm getting some correspondence from Ms. Hafner. Let me read that. All right. Ms. Hafner is indicating that he may be released from Volusia County. He may be out.
The last time I checked was on the 4th of February that he was there, so that may be true.
Yeah, we sent notice of his arraignment, and that was returned from the Volusia County Jail.
I can check very quickly, to give me a second. Yeah, that's correct, Your Honor. I don't see him coming up in Volusia County anymore.
All right. I'm inclined to set him, I don't know, let's set him for arraignment about 3 weeks out. So let's do it on February 3rd at 8:30. And Madam Clerk, if you will notice him and his bondsman and the last known address.
And Your Honor, is that March 3rd?
Did I say February? Yes, March 3rd. My apologies.
That's okay. Thank you, Your Honor.
This case that I have is Stephen Jones.
Marie Jimenez on behalf of Mr. Stephen Jones.
Do we have Mr. Espinal yet?
No, sir. As soon as we have space to get him up, we're going to get him.
Okay. Good morning, Mr. Jones.
Good morning.
All right, this is 2018 CF 2742.
Your Honor, in this case, the client was set for an evaluation. Dr. Arias sent me a report for this case. I'm not sure if the court has it.
I do not.
It was received yesterday. Apparently really late. I will be sending the report at this moment.
Okay. State, have you received a copy of the report?
I have not, Your Honor. I looked for it last night in the court file and checked with the services through our case management system and had not received it.
Yeah, I looked in the court file yesterday as well and do not have a copy of it. Ms. Jimenez, can you give us some guidance as to what the defense's position will be in regards to the report?
Your Honor, based on the report, again, it was received really late yesterday. That's why it wasn't filed. Dr. Arias finds is that the capacity of the client, deem him as an incompetent. He finds that he doesn't have an ability to testify relevantly. He does not have a capacity to disclose pertinent facts to the attorney. And his behavior in court is acceptable.
Okay.
His understanding of adversarial nature is impaired. He found that it's also an impairment of his understanding on the penalties that he may be receiving, and the appreciation of the charges are marginally acceptable.
All right.
I have forwarded the report to Ms. Butler, Ms. Hafner, and Mr. Collins at this moment, Your Honor.
Thank you, Ms. Jimenez. I received a copy of that report as you were speaking, so let me take a look. Dr. Arias opines that Mr. Jones may not be competent to proceed at this time and recommends some training to attain. State, I won't put you on the spot. It seems like this report just came in. Do you want an opportunity to review the report and make a determination as to whether you stipulate to the findings?
Yes, Your Honor. If we can just reset it for a week or so, just to give me a chance to go over the report and compare it to the last one, and then, like you said, make that determination.
All right, let's bring Mr. Jones back in 1 week, and that's going to be on the 13th. That's a pretrial date. We'll address this case at 8:30. Mr. Jones, the state wants an opportunity to read the doctor's report. They may agree with it or they may not, but we're all just reading this for the first time. So we're going to bring you back in 1 week. That's, I'm sorry, I gave the wrong date. That's going to be February 17th, 2/17 at 8:30. And we'll address your case at that point. So we'll see you in 1 week from today. Thanks, Mr. Jones.
Thank you, Your Honor.
If you'll file that confidentially, please. All right, do we have Michelle Lacy present? Put a question mark next.
Melissa Vickers on behalf of Ms. Lacy.
Ms. Vickers. Have you waited with us this whole time?
Yes, sir.
All right, thanks. What is the status on Ms. Lacy's case?
Ms. Lacy is in inpatient rehabilitation in Tennessee, so she is not able to be here today. We're still working on trying to get records. The problem is that they won't, acknowledge to us that she's even there. So her mom's trying to get the records for us to show that she's there and just has not gotten them as of yet.
Yeah, I've got no reason to disbelieve what you're telling me. However, this is, I think we've reset this a couple times to try and see if that would be able to be verified.
That's right, and there's already, I believe, a warrant out for her arrest. So we will, if the court just wants to leave it with a warrant, as soon as we can get some documentation, we'll set it for a court date, because I believe the whole thing was going to be dismissed once we showed documentation or had her present, so we can go ahead and set that as soon as we can get that information for you all.
All right, Ms. Vickers, I'm sorry to have an existing warrant if that proves to all be accurate, what your client is telling you, but I think I'm without any options and I've got no information to withdraw the warrant. So the warrant will remain outstanding, and if the circumstances change, please let my judicial assistant know and we'll handle that expeditiously.
Yes, sir, will do. Thank you.
Thank you. Anything further from the state on that case?
Nothing, Your Honor. Just like I said, we can get our states in the move to dismiss it and get rid of it.
Thanks. Do we have a Michael Mahias present in the hallway? All right, if you'll call one more time. All right, Mr. Mahias apparently is appearing virtually, so let me see if Mr. Mahias is joining us. I do see Mr. Mahias. Sorry about that, Deputy. He's going to appear virtually. Mr. Mahias, can you hear us? Mr. Mahias, are you with us?
Yes, sir.
All right, thank you. This is case number 2020 CF2474. Michael Mahias is joining us remotely. Who's the state on this one?
Benjamin Barrett for the state.
All right, thank you. Mr. Mahias, Mr. Sanchez has previously withdrawn. Have you had an opportunity to select another attorney?
No, sir. I'm at the time not going to be able to afford another attorney.
All right, I'm going to need to set you then for a determination of counsel date. You're going to need to come to the courthouse. I need you to fill out some paperwork to consider whether appointing the Office of the Public Defender or a conflict-free attorney would be appropriate at the expense of the state of Florida. I'm going to set...
May I say something, sir?
Yes, sir.
The public defender said it was a conflict of interest prior to me hiring Mr.
Do we have a previous report?
He was previously provisionally appointed when he was at initial appearances, and then they ended up conflicting off.
All right, thanks. All right, Mr. Mahias, we'll make sure that we get conflict-free representation if you qualify. I'm going to need you to come into court to make that determination. Are you local?
I'm actually in Tampa, sir.
All right.
I was trying to get there this morning, but there would be no buses that would get me there until this afternoon.
Pursuant to the administrative order, you are permitted to attend today virtually, and the court will note your appearance. But I will need you to be physically...
On the 15th, I have transportation for the 15th.
All right, thank you. We'll anticipate seeing you on February 15th for pretrial in person, and we'll address your representation at that time.
Yes, sir.
All right, we'll see you then. Anything further from the state?
No, Your Honor.
All right. Thank you. That will conclude our hearing today. Mr. Mahias, we'll see you on Monday.
Yes, sir.
All right, the next case that I have is Fernando Taylor, 2020 CF2167.
He hasn't made it to the courtroom yet, Your Honor.
All right, thanks. We'll come back to Mr. Taylor's.
Your Honor, I think I can address Mr. Taylor without him being present. Willie Jimenez for the record.
All right, thank you. This is 2020 CF2167. This was originally set for a plea date certain. We've gotten an indication on the 9th that this is no longer going to be a resolution. Is that correct?
Yes, Your Honor. My client, I was speaking with him yesterday, and he told me that he doesn't want to plead to the charge, including the one that we were supposed to plead him out on Orlando. That was 20 CF 6376. Client does not want to plead at this time, Your Honor.
All right, thank you. Mr. Taylor remains in custody on these two cases, so we will add him to our April trial list with a pretrial. Pretrial is going to be on March 24th with a trial period that begins April 5th.
Thank you, Your Honor.
Thank you. And corrections, Mr. Taylor will not need to be brought to the courtroom. All right, do we have Mr. Gonzalez Rivera present? Good morning, sir.
Good morning, Your Honor.
We're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, in 2020 CF 2269, the court received correspondence from Mr. Gonzalez Xavier requesting the return of his property that was seized based on an allegation of a criminal offense. This court reached out for the state's positions. My understanding that the state of Florida objects. Is that correct?
Edwin Muff for the state. That's correct, Your Honor. And Mr. Campo with the Osceola County Sheriff's Office is also, I believe, waiting in the lobby.
All right,
for this
thanks.
case.
Let me admit Mr. Campa.
Your Honor, this is Ebony Cobb with defense. Our office represented him at the time of plea. He did file his own letter, but if the court will allow me, I'm here to assist.
All right, thanks. If you are willing to continue your representation of Mr. Xavier, Mr. Gonzalez Xavier, the Assistant Public Defender is present, and she is willing to act as an advocate on your position. Do you wish to have her services?
Yes.
All right, thanks. Thank you. The court is joined by Mr. Campa. Mr. Moffitt.
Good morning, Your Honor.
Good morning. Do you wish to present witnesses or evidence in support of your opposition to the defendant's motion?
First, I would just ask that the court take judicial notice of the plea agreement in case 20 CF 2269, as well as the charging affidavit that is contained in the court file. And Mr. Gonzalez's letter, that's also contained in the court file.
All right.
Besides that, the state doesn't wish to present any other evidence. I just have argument.
Let me take a look at the plea agreement. All right, thank you. Ms. Cobb, do you wish to present any witnesses or evidence?
Judge, I just want to call my client as a witness.
All right, thank you.
I think he's already been placed under oath. I'm not sure, actually.
I don't think we
We
did. All right, we did place him under oath. Ms. Cobb, when you're ready.
Okay. Good morning, sir. Could you please state your name for the record and spell your last name, please?
Samuel Gonzalez Xavier. Gonzalez.
Thank you, sir. And are you asking this court to return some electronics that were seized as a result of this plea agreement?
Yes, ma'am.
Why are you asking the court to do that?
Because, I don't know everything they took, but I believe it was only one item that they used for the charges, and the other stuff is, has family, photos and video of my mom and dad and who are passed, and sisters and, brothers and, and my writings that I've been working on.
Okay, sir. So specifically, and I just want you to be specific as possible, what are you asking the court to return back to you once you're out of custody?
I mean, I would hope to get everything back except the item that was used for the charges.
So are you asking the court to return the electronics that were not used in the underlying case?
Yes, ma'am.
Now, on the plea agreement, you and your attorney agreed to forfeit all electronics. What is your what was your thought process at that time? Why did you agree to forfeit all electronics?
I wasn't in my, in my right frame of mind. I was, stressed out about, the charges and what was going to happen. And, I wasn't really there.
And when you, signed this plea form, were you under the assumption that all of the electronics that were related to the case would be taken?
Yes, ma'am.
Do I need to rephrase the question?
She said, he responded, yes, ma'am. Were you able to hear that?
Oh, I'm sorry. Okay. One moment. And inside of your letter, you mentioned that you're interested in getting photographs and different writings that you had on some electronics. Is that true?
Yes, ma'am.
Is there any other personal items that were on the electronics that you want back?
It was all videos and photos and writings.
Thank you. Judge, I don't have any other questions.
Mr. Moffitt, any questions?
I have no questions, Your Honor.
All right, thank you. Any additional witnesses or evidence, Ms. Cobb?
No, sir.
All right.
Just argument.
I'm ready when you are.
Judge, I have two arguments. The first argument, I'm looking at the plea form, and it says forfeit all electronics. One could make the argument that these electronics, by signing the plea form, he was agreeing to forfeit all electronics that were germane to the underlying case, and not all of the because they took his laptops, some SD cards that didn't contain illegal material on them. So that's my first argument. My second argument is if the court believes that he agreed to forfeit all of his electronics, he did not agree to forfeit the photographs, his writings, information from his loved ones that was contained inside of within those electronics. So if the court could fashion an order where he could, once he is released from DOC, where he could go to the sheriff's office with a blank SD card, a memory stick, and receive just his photographs and not the illegal material, then I think that would be a good resolution to this case, because it sounds like from his letter that he just wants photographs and some letters and some writings that were contained in the electronics and not necessarily the illegal material.
Mr. Moffitt, response?
Yes, Your Honor. The first thing the state would note is that I don't believe Mr. Gonzalez Shiver's letter is a facially sufficient motion to return the property. To be facially sufficient, it would have to allege that it's his personal property, that it's not the fruit of criminal activity. He would have to allege that the property is not being held as evidence, and then he would also have to specifically identify the property. There were a significant number of items that were collected by the Osceola County Sheriff's Office in this case and submitted as evidence as part of a probation search that turned into a investigation done by the Osceola County Sheriff's Office. Based on the charges that the defendant pleaded to, some of those items contained child sexual abuse material, and that was part of the reasoning behind why as part of the negotiated plea agreement with Mr. Gonzalez, that he would agree to forfeit all the seized electronics in this case. If the court wants to hear from Mr. Campa as to how any logistics of that would work, I would defer to him, but I think it's the state's position that that the motion is not facially sufficient because it doesn't identify what he needs to be returned, so I don't think the court needs to address the merits of the motion today, but if the court does find it sufficient based on his testimony, then I think based on the plea agreement, as it's clearly outlined, he has agreed to forfeit any and all of those seized electronics.
All right, thank you. As to the first issue, obviously, Ms. Cobb has done a good job of highlighting a potential argument regarding the return of electronics. The court finds that the plea form is plain in its meaning, and a physical return of the electronic devices is going to be denied based on his agreement with the state of Florida in the contemplated resolution of this case. As to the backup request that he be provided a means to collect some family photographs and some writings, Mr. Moffitt, does the state have any ideas as to whether that request can even be accommodated?
I would have to defer to the digital examiner at the Osceola County Sheriff's Office. To my knowledge, not every single device that was taken has likely done a full forensic review, so I'm not 100% sure if that could even be facilitated.
All right, is it Detective Campa?
No, Your Honor, it's Jose Campa. I'm legal counsel with the Sheriff's Office.
Gotcha. All right, thanks. Mr. Campa, any ideas as to whether that even is a possibility, or whether an outside agency could be employed to come see if they can get some documents, some photographs off the electronic devices?
Your Honor, I believe if the defendant comes in to the Sheriff's Office, he should have, say it's a computer, he might have access to it. We can have a detective with him, and they can kind of see what's being downloaded to a thumb drive. In all honesty, my concern would be not being involved with the case from the beginning. I would be concerned that they may open a file that was not previously looked at by law enforcement, and voila, more child pornography is discovered. So that's my only concern when it comes to possibly opening the door to further crimes. But if that's what the defendant wants to do, we can accommodate them and sit with them and download some files with them.
All right, thanks. I think that's a reasonable request on behalf of Mr. Mr. Gonzalez-Chavert. Court's going to deny the request to physically return the property. The court will allow Mr. Gonzalez-Chavert to physically go to the sheriff's office and at his expense, with the assistance of a detective, access personal family photographs and personal writings as requested in his motion. So the court will fashion an order with that language, and if we run into an issue, Mr. Gonzalez-Chavert, with the technical aspects of that, that's going to be at your expense to try and consult with an expert to see if you can pull that information back off the seized property. Also, and I'm sure Ms. Cobb will advise you, if there is other items that have previously gone undiscovered, you run the risk of additional criminal sanctions. So, anything further, Ms. Cobb? Can you think of any other language you'd like to be in an order?
No, Judge, that's it.
All right, Mr. Moffitt, anything further?
The only thing I think the court may want to consider in the order is Mr. Gonzalez is serving, I believe, a 10-year prison sentence, and now that there was a forfeiting of the property, to, I guess, instruct the sheriff's office not to destroy any of those items if he's going to do that request in
Ms. Cobb,
10 years.
I'm going to ask that Mr. Gonzalez-Chavert update the court with a list of the items in which he would like to be preserved pending his release. So he's going to have to let the sheriff's office know which items he would like to be held for quite some time pending his release.
Yes, Judge. And what I can do is I can follow up with a supplemental proposed order if he wants to get a family member to do it on his behalf. That way we can expedite the process. I just need to talk to him about that.
All right, thanks. Why don't you coordinate with Mr. Moffitt on a proposed order? I'll need to know what item specifically he wishes to access, and I'm happy to make reasonable accommodations to get off his family photos and his personal writings.
Thank you so much.
All right. Thanks. That's going to conclude our hearing, Mr. Gonzalez-Chavert.
Thank you, Your Honor.
Thank you.
Your Honor,
Yes.
Mr. Espinal's in the courtroom now.
All right. Thank you very much for that information. We're going to call Mr. Espinal's case at this time.
Thank you, Your Honor. May I be excused?
Yes. Thank you, Mr. Camper.
Thank you, Judge.
Minutes on behalf of Mr. Espinal.
Peter Dunn for the state.
Your Honor, in this case, I filed the report with the court. I just want to confirm that the court did receive this one.
I did. Thank you.
This was received with time, yeah.
All right. Thank you.
Thank you, Your Honor.
Good morning, Mr. Espinal.
How you doing?
I'm fine. Thanks for asking. Ms. Jimenez, I have reviewed the report. Is the defense in a position to stipulate to the report and the findings contained therein?
Your Honor, the state attorney, I was communicating with Mr. Donnelly, and he informed me that he would like Dr. Arias to supplement the report as to the facts of what are the factors that he's taking into consideration to recommend state hospital. I did that request to Dr. Arias. I'm still waiting for that. I will be asking the court if we can reset this hearing for at least 2 weeks so the Dr. Arias can supplement the record on that report.
State?
Yes, Judge. I don't know if Your Honor is satisfied with the state hospital recommendation. The doctor just says he meets the qualifications. He doesn't indicate how. That's my concern.
That was my thought as well in reading the report. I think there needs to be a more in-depth analysis as to the reasoning behind that petition, that specific request. I'm inclined to see if you guys can get an updated report from the doctor and then make a determination. Court can accept that by stipulation, or if it's not stipulated to, then court can appoint a second expert to opine whether that's reasonable or not.
Yes, Judge.
Ms. Jimenez, you're requesting a reset. How long?
I anticipate Doctor is answering to me really quickly, so I think 2 weeks or 3 weeks should be enough, Your Honor.
All right. Why don't I set this for February 3rd? I'm sorry, I keep doing that. March 3rd at 8:30.
I think that's perfect, Your Honor.
All right. Thanks. All right, sir. We need a little bit more information from the doctor to make some decisions, and we anticipate we'll have that by March 3rd. We're going to bring you back before the court, and hopefully Ms. Jimenez will have some additional information for you before that date, and we'll see you then. Thank you.
Thank you, Your Honor.
All right, let me admit Mr. Smith and Mr. Zaleski. Good morning, Mr. Smith. Good morning, Mr. Zaleski.
Good morning.
All right, I think Mr. Smith may have stepped away. Nope, he's back. Mr. Smith.
Good morning, sir. My apologies.
Not a problem. Mr. Smith, I have you on for a 9:45 hearing with Mr. Ortiz Bernard. Do we have Mr. Ortiz Bernard?
Yes, Your Honor.
Thank you. Mr. Smith, does Mr. Ortiz Bernard need the assistance of an interpreter?
He does, Your Honor.
Good morning, Your Honor. This is Carlos Morales, State Certified Spanish Interpreter. The interpreter has been sworn in already today.
Good morning, Mr. Morales. We have Mr. Ortiz Bernard. He is at the Osceola County Jail Facility. The case number is 2019 CF 525. You'll be doing the interpreting over the intercom system. Good morning,
Yes, Your Honor.
Thank you. Good morning, Mr. Ortiz Bernard.
Buenos días, señor Ortiz Bernal.
Mr. Ortiz Bernard, I am looking at your attorney, Mr. Smith, on my computer screen, as well as the Assistant State Attorney. Is that Ms. Rosado?
Yes, Your Honor. Good
All
morning.
right, good morning. We are set for a competency status date. Can you tell me what the status is?
Well, Judge, we were supposed to have a competency hearing. We were waiting for defense to follow up when he was appointed to the PD's office. They withdrew from the case, and then Mr. Smith was appointed. We have two evaluations that are now stale, so I believe Mr. Ortiz would need to be reevaluated.
All right, we are here based on Mr. Ortiz's letter to the court on January 28th, 2021. Seems to be a fairly cogent letter that indicates that he's been incarcerated for some time and is back from state hospital on November 6, 2019. Mr. Smith was appointed as a conflict-free attorney. And Mr. Smith, have you had an opportunity to discuss Mr. Ortiz Bernard's situation with him?
I have, Your Honor. However, to be frank, when I went to see my client, I was not aware that language was an issue for him. There was an individual, to be very candid here, who'd called from the jail, representing himself as Mr. Ortiz Bernard, and spoke perfect English. And so I then made arrangements to go and see someone who turned out to be the actual real Mr. Ortiz Bernard, who did not speak English very well. I know just enough Spanish to explain to him that I was an attorney appointed to represent him. Not sure why, but for whatever reason, he did not believe or accept that I was a lawyer. And in part because he thought that the person who would be coming to see him would be white as opposed to black. And so, therefore, I made arrangements to send some correspondence, perhaps suggesting that someone else should be appointed who's able to speak Spanish. I'll be candid, I believe that fell through the cracks. I left the firm where I was when I was appointed to this case. So I think given the history of this case and the language issues, that it might be most appropriate to have a lawyer appointed who can speak Spanish, so as to help facilitate the movement of the case.
All right, thank you, Mr. Smith. Do we have any conflict attorneys that are Spanish speakers?
I'll pull that now.
I think we've forgotten about Mr. Morales. Mr. Ortiz Bernard, are you most comfortable speaking Spanish?
Señor Ortiz Bernal, ¿usted se siente más cómodo hablando en español?
You need to get closer to the microphone, please.
Acérquese al micrófono. ¿Se siente usted más cómodo hablando en español?
Sí.
Yes.
We can do Ted Marrero, Migdalia Perez.
Let's do Ms. Perez. All right. Mr. Ortiz Bernard, based on the issue of the language in which you are most comfortable to talk to your attorney, we are going to allow Mr. Smith to withdraw based on what has been represented to the court, and the court will appoint Ms. Migdalia Perez to represent you. She will be getting notice that she now represents you. She's local here in Kissimmee and will be out to talk to you about your case. Ms. Rosado, if you will coordinate with Ms. Perez, sorry, Sorry, Mr. Morales.
No, yes, thank you. Señor Ortiz, dado a la situación que hay con el idioma, que usted se siente más cómodo, ¿verdad? Con el cual usted prefiere hablar o consultar con su abogado, pues se está permitiendo a que el señor Smith sea despedido o se retire del caso y se le está nombrando a la abogada Migdalia Pérez para que ella lo represente a usted. Ella recibirá una notificación, ella se encuentra localmente, ella está en Kissimmee y ella saldrá a hablarle pronto.
I will set this for a competency status hearing on March 10th at 8:30.
La próxima vista será una vista de seguimiento sobre las facultades el 10 de marzo a las 8:30 de la mañana.
Mr. Smith, are you still with us?
I am, sir.
All right, thank you. I apologize for the circumstances that necessitated your withdrawal in this case. Good luck to you, and we'll see you next time.
Thank you, sir. And I can understand him not understanding my role. The good news is at least he didn't think I was a cat, so I think everything's fine.
I've seen that video too. Thanks.
All right, take care, everyone.
See you, Mr. Smith. All right, you've been appointed a Spanish-speaking attorney, sir. They'll be out to talk to you about what your options are, and I have set you for a status in 30 days so that we don't lose track of your case.
Muy bien, señor. Se le ha nombrado un abogado que habla, una abogada que habla español para que ella vaya y entonces va a ir a hablar con usted y para que le explique cuáles son sus alternativas, y hemos programado una vista de aquí a 30 días para que pues su caso no pase desapercibido.
And Judge, if I can, will the court reappoint Dr. Ruiz, who is one of the doctors who spoke to the defendant, to do an evaluation, so by the time we get to March, we can probably get that done?
If you will run that appointment by Ms. Perez, indicating that she's been recently appointed, I have no objection to signing off on that request, and Chambers, I'll need an order.
No problem, thank you.
Thanks. All right. That will conclude our hearing. Thank you.
Muy bien, así concluye esta vista. Gracias.
Okay, gracias.
Thank you.
Thank you. Mr. Zaleski, does Ms. Marrero need the assistance of an interpreter?
No, she does not.
All right, thank you. Mr. Morales, thank you for your help. We'll call back when we need additional assistance.
Yes, Your Honor. Thank you.
Thanks. All right, this is Amanda Marrero. Good morning.
Good morning.
We have three cases, 2019 CF 3838, 2019 CF 4329, and 2020 CF 3467. These cases are set for a plea. Let's swear in Ms. Marrero.
Please raise your right
Your
hand.
Honor, there are also two out-of-county cases that you should have there.
Okay.
You don't have the plea forms for them? You just were notified.
Okay, I don't have any plea forms for those out-of-county cases, but if we've got authorization to address them, then I can do that for you.
I can email them to you if you'd like.
All right, thank you. And who
What's
is this?
What email address?
It's going to be to Ms. Butler or to Ms. Hafner.
Okay.
Send an email, so email me back.
Let me take a look and see if I've got them. I may have them already. Ms. Hafner may have anticipated this.
Your Honor, Lindsay Card for the state. I believe Ms. Hafner received the two plea forms for the two orange cases sometime last week.
Got
And
it.
then I sent up the arrest affidavits and informations along with the global score sheet yesterday.
I've got it all, Ms. Card. Thank you. I just found it. Thank you for that courtesy.
Perfect, thanks.
All right, give me just a minute to get situated, and then we'll address Ms. Marrero's cases.
Can you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and Ms. Card, the Orange County cases would be 2020 CF 9179 and 2020 CF 3467.
2020 CF 3467 is actually an Osceola case.
Oh.
The orange cases are 2020 CF 2302. And then the 9167 case you mentioned was actually encompassed into a different case number. So the proper case number is 2020 CF 4122.
All right, Ms. Marrero, you have been sworn, and I've got a number of plea forms and proposed resolutions in this case. One's on 2019 CF 3838, alleges 2 counts. Count 1 is grand theft, and count 2 is resisting merchandise recovery. It's a third-degree felony allegation and a first-degree misdemeanor allegation. The plea form indicates that you wish to plead no contest to those allegations. Is that what you wish to do?
Yes.
And in 2019 CF 4329, document indicates that you wish to plead no contest to 1 count of petty theft with 2 prior theft convictions. That's a third-degree felony allegation. Is that what you wish to do?
Yes.
And in 2020 CF 3467, document indicates that you wish to plead no contest to 2 counts, count 1 being petty theft with 2 prior theft convictions, and count 2 being resisting merchandise recovery. Is that what you wish to do?
Yes.
And count 1's a third-degree felony allegation, count 2's a first-degree misdemeanor allegation. In 2020 CF 2302, document indicates that you wish to enter a plea to grand theft, a third-degree felony allegation. Is that what you wish to do?
Yes.
And finally, in 2020 CF 4122, the document indicates that you wish to enter a plea of grand theft, a third-degree felony allegation, a plea of no contest. Is that what you wish to do?
Yes.
As to each of these cases, do you understand that you have a right to have a jury trial?
Yes.
And at the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of every offense that you were charged with. At all of those trials, Mr. Zaleski would have been with you, would have cross-examined witnesses and examined evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have testified, or you could have remained silent and not testified. That would have been your decision after you talked things over with your attorney, and your jury would have been instructed not to consider that decision in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in those processes. Do you understand you are giving up all of your trial rights in each of these cases and each of the counts contained therein? Because if I go along with this global agreement, I'm going to go along with the agreement that is proposed, and we are not going to be having trials as to any of these matters. Do you understand that?
Yes.
Is anyone forcing you or pressuring you into making this decision?
No.
Has anyone made you any promises other than what are contained on your plea forms?
No.
Are you under the influence of any alcohol, any drugs, or any mental issues that cause you not to understand the decisions that you're making?
No.
Do you understand if you are not a United States citizen, entry of these pleas would subject you to deportation?
Yes.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of these pleas could subject you to involuntary civil commitment. Do you understand that?
Yes.
All right, thank you. As to 2020 CF 3467, 2019 CF 4329, 2019 CF 3838, 2020 CF 4122, and 2020 CF 2302. Mr. Zaleski, is the defense stipulating to factual bases for purposes of acceptance of the plea?
Yes, Your Honor.
Court accepts that stipulation, finds I have a factual basis with which the court can accept these pleas, finds Ms. Marrero appears to be alert and intelligent. She's had an opportunity to think about this decision and discuss it with Mr. Zaleski. Are you satisfied with Mr. Zaleski's help on these 5 cases?
Yes.
Seems like he wrapped everything up for you. You've indicated to me, yes.
All right. The 2 Orange County cases, I'm actually covering them for Leon Cheek, and he has advised me that he's had conversations with the defendant and she understands everything about those cases.
All right, you satisfied with Mr. Cheek's services on your Orange County cases?
Yes.
Thanks, Mr. Zaleski. Court finds Ms. Marrero appears to be alert and intelligent. She's had an opportunity to think about this decision, discuss things with her separate attorneys. She's indicated to me no one has forced her, pressured her into making this decision. Does so of her own free will. As to 2020 CF 3467, the court will adjudicate her guilty as to counts 1 and 2. As to that case, she will be sentenced to 6 months in the Osceola County Jail. She will get credit in 2020 CF 3467 with the time that she has already served, which is?
87 days.
Which is 87 days. She is agreeing to pay $720.86 in restitution. There will be court costs assessed on top of that.
Court costs of $418, $100 cost of prosecution, $250 regional conflict lien, and the restitution was $720.86.
It is $720.86.
How many days of credit did you say on that case?
87 days.
Okay.
And that grand total is $970.86.
And Your Honor, there's also a no return to the scene.
All right, thank you. Yeah, I see that on the plea form. You're not to return to the Home Depot. In 2019 CF 4329, you will be adjudicated guilty as to count 1. You'll be sentenced to 6 months in the Osceola County Jail. Is that a concurrent sentence, Ms. Card?
Yeah, these are all concurrent.
Yes.
That will be served concurrently, meaning at the same time as any other case that we're going to sentence you on today. And you are agreeing to pay restitution in the amount of $794.99 to Home Depot. We'll give you credit for the time that you have already served in this case.
172 days.
And you will owe court costs in this case as well.
Court costs of $418, $100 cost of prosecution, $250 regional conflict lien, including the $794.99 of restitution. That total is $1,562.99.
In 2019 CF 4329, you will be adjudicated guilty as to count 1, petty theft with 2 prior theft convictions.
That's the one I think we just did.
Did I just do that one? Is it 3?
So I think we should be on 3838 for her last Osceola.
3838?
Yes, Your Honor.
As to 2019 CF 3838, you'll be adjudicated guilty as to counts 1 and 2. You'll be adjudicated guilty, sentenced to 6 months in the Osceola County Jail. In that case, you will get credit for?
172 days.
You are agreeing to pay restitution in the amount of 823 days to Home Depot. And there will be court costs assessed in that case as well.
Court costs of $418, $100 cost of prosecution, $250 regional conflict lien, including the $823 of restitution. That grand total is $1,591.
In the Orange County case, 2020 CF 4122, you will be adjudicated guilty of grand theft. You'll be sentenced to the time that you have already served in the jail, which is? Does anybody know what her time served is in the Orange?
90 days. I'm sorry.
90?
90 days.
Thank you. You're sentenced to 90 days with credit for the 90 days that you have already served. You are ordered not to return to the Walmart. You're agreeing to $33.53 cost of investigation to the Orlando Police Department and court costs. This sentence will run concurrently, meaning at the same time as any other sentence.
I'm sorry, what was the cost of investigation?
$33.53.
Thank you, Your Honor. Court costs of $418, $100 cost of prosecution, $250 regional conflict lien, and the $33.53 for cost of investigation. That total is, $801.53.
Your Honor, I just had 2 quick clarifying questions.
Okay.
And I'm sorry I'm a little late, but in 19 CF 3838, I think you might have said 823 days of restitution, and just for clarification purposes.
Yeah, if I said that, I misspoke. $823 in restitution to Home Depot.
And then my next question, the sentence you just announced, what was that case number? I might have been looking at the wrong thing, but I think they might be switched. So I just want to make sure I have the right.
You had indicated to me that it was encompassed under 2020 CF 4122.
Yes, so 20 CF 4122. I think you announced the sentence that was intended for 20 CF 2302. So 20 CF 2302 is the adjudication of guilt, credit time served, $33.53 of cost investigation.
I did.
And then the one that's encompassed into 20 CF 4122 is that 20 CF 9167 case. So that's what's on the arrest affidavit, but it's encompassed into 20 CF 4122. That's a different sentence.
Okay, we had that number as 2020 CF 9179. Is that the?
Yes, I misspoke now.
Okay, all right.
Sorry.
A lot of numbers. Okay, so the sentence that the court has previously just announced was on 2020 CF 2302, an adjudication to grand theft, credit for time served of 90 days. No return to the Walmart, cost investigation to OPD to run concurrently, plus court costs. In 2020 CF 4122, to be adjudicated guilty of grand theft, be sentenced to 120 days in the in jail, and I guess that'd be the Orange County Jail. And what is the credit for time served?
So in that case, it's going to be 133 days.
You've already served your time on that case. You are not to return in that case to.
Sorry, I
Okay.
sent them too.
Right.
So in 2302, she has 133 days, and he's got a 90-day sentence.
Correct.
And in her 4122, the one we're on, she has 90 days.
Okay, so she doesn't have a 90-day sentence. She's got credit for time served in 2322. So that credit for time served is what?
133 days.
In 2020 CF 2302, the sentence is 133
days.
3 days with 133 days credit for time served. In 2020 CF 4122, she's sentenced to 120 days in jail with 90 days credit for time served. She's not to return to the Walmart. She's agreeing to $766.81 in restitution to Walmart, as well as court costs.
Court costs of $418, $100 cost of prosecution, regional conflict lien of $250, including the $766.81. That grand total is $1,534.81.
Court's going to, on the three Osceola County cases, 2019 CF 3838, 2019 CF 4329, 2020 CF 3467, costs are to be paid to the clerk of the court collection program within a period of 36 months. Any money that is paid will go to restitution first. As to the two Orange County cases, 2020 CF 2302 and 2020 CF 4122, it's ordered to make payments to the clerk of the court collection program within 36 months. To the Orange County clerk of the courts, any payments will go to restitution first. As to all of your cases, you have a right to appeal the judgment and sentence. If you wish to do so, you must do it in writing. If you can't afford an attorney, one will be appointed for you. Ms. Carr, did I miss anything? No.
That's perfect, Judge. Thank you so much.
Mr. Zaleski, anything further?
No, Your Honor. Thank you so much.
All right, thank you. Good luck to you. All right, I'm going to let Ms. Minyarji sing in to accomplish her resolution. Ms. Minyarji Singh, good morning.
Your Honor, how How are you?
I'm doing just fine. Thanks for your patience. We are here on Jose Figueroa Rivera.
Yes, Your Honor. I do have his parents here in my office as well behind me. And they, if we do decide to move forward with the plea, they would like to be heard prior to sentencing.
Okay.
Please.
Judge, in the lobby, Angela Bermudez.
All right.
And my
thank
victim
you.
advocate,
I'll admit Ms. Bermudez.
Lisa Reynoso as well.
And Ms. Reynoso. All right, we are joined by Ms. Bermudez, and we are joined by Ms. Reynoso. Ms. Bermudez, Ms. Reynoso, the Assistant State Attorney, Mr. Donnelly, is both present in court and on the Teams meeting. You should be able to see him. Present also is Ms. Minyarji Singh. At the jail facility is Mr. Figueroa Rivera. Ms. Minyarji Singh, does your client need an interpreter?
He does, Your Honor. I was just going to ask if there was one on the line.
There's not.
He had there was one present the last hearing. I apologize. I thought that we established that last.
Yeah, we've got thousands of cases, Ms. Minyarji Singh, so let Ms. Hafner know who needs interpreters. We'll get one on board.
Good morning, Your Honor. For the record, Jose Sendra, certified Spanish interpreter, previously sworn in.
Thank you. Good morning again. We have Mr. Figueroa Rivera. Case number is 2019 CF 3990. Mr. Figueroa Rivera is at the jail facility. You will be interpreting over the intercom system.
Thank you, Your Honor.
Let's swear in Mr. Figueroa Rivera, please.
Please raise your right hand.
Señor, por favor, levante la mano derecha.
Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, nothing but the truth, so help you God?
Usted jura y afirma que el testimonio que dará concernientes a esta causa será la verdad, toda la verdad y nada más que la verdad con la ayuda de Dios?
Sí.
Yes.
All right, Ms. Minyarji Singh, what are we doing this morning?
¿Qué vamos a hacer hoy, Fiscalía?
Your Honor, we are here for a plea conference with the court. Before we start, I just wanted to ask the state one last time. I know we had this conversation, but I wanted to ask the state if the state would be amenable to the defendant pleading to a misdemeanor in this case.
No, Judge.
La Fiscalía rechaza la oferta.
The last time we had the bond hearing, the state put on the record their last offer, which was an adjudication with 5 years probation and other conditions. I spoke to the court about possibly pleading to the bench. The court acknowledged that it might give this defendant less time than 5 years due to the fact that it was his first incident. I believe he had one prior that was dropped, so he has no convictions on his record. He has been in jail for this offense for a few weeks now. I do have his parents here in the office to, speak to the court as well as far as potential adjudication, because we are seeking a withhold. I understand it's a second-degree felony, but we do have some mitigating circumstances that we'd like the court to hear.
All right, do I have statutory authority to withhold? I'm sorry, Mr. Interpreter.
Estamos aquí, quisiéramos hablar con el tribunal y con la fiscalía para ver si esos 5 años de probatoria y el tribunal podría darle menos tiempo al acusado, ya que es su primer incidente. Podemos ver que estamos aquí en el tribunal con sus padres para dirigirnos a su señoría. Lleva varias semanas en la cárcel y que pudieran mantener el fallo de culpabilidad en suspensión.
Mr. Donnelly, does the court have authority to withhold on a second-degree felony without state permission?
Señor Donnelly, el tribunal tiene autoridad para mantener el fallo de culpabilidad en suspensión en un delito de segunda categoría.
Judge, the court would have to make written findings in this case, stating that a withhold of adjudication is reasonably justified under the statute of mitigating circumstances.
Su señoría, el tribunal tendría que mantener por escrito que su disminución de las acusaciones sería razonablemente fundado.
Or have a written request from the state attorney in this case.
o por alternativa tener un escrito de petición por parte de la Fiscalía.
Thank you. All right, Ms. Minyarji Singh, do you wish to present any testimony or evidence for the court's consideration?
I do, Your Honor. I just wanted to put on the record if I could just ask the defendant, just so it's on the record because he is at the jail, if he does wish to proceed with pleading to the bench at this time on the first case, just remind him it's the felony case that we're here on today.
Su señoría, en este momento sí tenemos algún pruebas y testimonio, pero sí quisiera poner en actas y preguntarle al señor acusado si él quiere seguir adelante, y esta es por la primera causa del delito por lo cual nos trae aquí.
Did you respond to the question, sir?
Usted, señor, ha respondido a la pregunta de que si quiere seguir hacia adelante.
No.
No.
All right.
Did he understand that? Let me rephrase my question. His parents are behind me. They're saying that he didn't understand the question. Judge, is there any way that we can have a screen where we can see the defendant as well, or is that not possible?
Tengo a sus padres aquí conmigo, su señoría. ¿Hay alguna posibilidad que tenemos una pantalla para poder ver al acusado ya que se encuentra en la cárcel del condado?
Ms. Minyarji Singh, I'm happy to turn my laptop to where you may be able to see the video screen. That's the only solution I have for your request. Are you able to see the...
Okay. Yes, I can see. Jose, at this time, I know we spoke over the phone with your parents while you were incarcerated, and we talked about possibly accepting a probationary offer on the felony case. And you stated to me that you did want to take a plea if it was probation. Do you still want to move forward with a plea in this case, or did you want to go to trial on the case?
Señor, ya sé que hemos hablado hace tiempo atrás por teléfono con sus padres que usted está encarcelado, pero usted nos expresó de que estaría dispuesto a aceptar una declaración donde eso sería una oferta de tiempo de régimen de libertad vigilada, o sea, probatoria. ¿Usted quiere seguir adelante con esta decisión suya de aceptar tiempo de probatoria?
Sí, seguro que sí.
Yes, of course I do.
Of course you do what? Want to take the plea on the case or go to trial on the case?
Sí, ¿quiere hacer qué? ¿Tomar la declaración acordada o quiere ir a juicio? ¿Qué es lo que desea hacer, señor?
La decisión acordada.
I would like to take the plea agreement. Okay. So, Your Honor, we are here today to go to the court, because the court did indicate that it would possibly offer less time on his first time for a felony. And we do have mitigating circumstances that we'd like to present to the court according to statute 921.0026, which speaks about mitigating circumstances and the court's ability to withhold adjudication in this case.
Su señoría, nos encontramos hoy aquí y le pedimos a usted que si pudiera adjudicar menos tiempo para este delito, ya que tenemos unas circunstancias mitigantes en el caso y nos acogemos a la ley de los estatutos 921.0026, en el cual nos habla de los factores mitigantes en esta causa.
Ms. Minyarji Singh, has your client filled out a plea form and gone over that with you?
Señora Minyard, su cliente ha rellenado la declaración, el formulario de declaración, y lo ha repasado con usted.
He has not, Your Honor. I wasn't sure, given the circumstances, if Your Honor would do an oral plea or if he would still require a written plea, but I do not have a written plea.
Su señoría no lo ha hecho con nosotros, pero debido a las circunstancias no sabía si su señoría aceptaría una declaración oral o quisiera hacerlo por escrito.
Court will need a written plea form indicating that Mr. Figueroa Rivera understands the rights and obligations pursuant to his plea.
Este tribunal desea que el acuerdo de la declaración sea por escrito para asegurarnos que el señor Figueroa Rivera entiende los derechos y las consecuencias de su declaración.
Your Honor, given the fact that my client's going to plead to the case, would the court once again entertain, I'm not sure if I'm able to go to the jail due to the circumstances surrounding what's happening with COVID. Would Your Honor allow my client to at least be able to come and meet with me outside of the jail in terms of the plea, if we set it for sometime this week or next week?
Su señoría, debido a quisiéramos con la venia del tribunal que pudiera acogerse a una declaración no escrito, ya que no me da tiempo, y también debido a la situación de pandemia, a acercarme a la cárcel para reunirme con mi cliente, y pedimos por favor que su señoría permita una reunión fuera de la cárcel con mi cliente durante esta semana o la semana que viene.
We just had a request for bond on this case, and the court went through the analysis for bond. I understand the reason for the request, Ms. Minyarji is saying, but that request would be denied.
Entiendo que su solicitud, acabamos de tener también una solicitud para el tema de lo que es la fianza, y debido y sopesándolo mucho, su petición queda denegada.
Are you doing in-person plea hearings in the courtroom?
Su señoría, ¿usted está tomando las declaraciones en persona en el tribunal?
After the 15th, we're permitted to do in-person hearings.
Después del día 15 se nos permite que sea en persona aquí las audiencias.
Okay. I will, or are you able to schedule it now, or should I contact your J-aide for hearing time next week?
¿Puede fijar una fecha ahora o tengo que contactar con su asistente judicial para un aplazamiento y nueva fecha?
If all the paperwork is ready to go, I can do it as early as the 17th at 8:30.
Si los documentos están listos, podemos hacerlo lo antes, pues eso sería sobre el día 17.
I believe I'm also in your court, Your Honor, on Monday the 15th for pretrial in another case. Is that virtual or is that in person?
También, su señoría, yo tengo una audiencia con usted el lunes día 15. No sé si eso será en persona o por remoto.
That's going to be pretrial. If I believe that you may appear virtually for pretrial. If the paperwork was in, I could do the plea at 8:30 on that date.
Esa va a ser una audiencia previa y me parece que va a ser virtual. Si los documentos estuvieran listos para ese día, se podría hacer virtualmente.
Actually, you know what? If you're anticipating presenting witnesses, I won't have an opportunity to do that right before pretrial.
Y también si usted está presentando testigos, no puedo hacer eso antes de las audiencias previas.
I am thinking the 17th in the afternoon would be probably the most appropriate time if you need more than just a few minutes, and that would be around 2 o'clock.
Estoy pensando que el día 17 por la tarde sería el momento más apropiado para ello, y también pues a las 2 de la tarde sería lo indicado.
Mr. Donnelly, I know that you have witnesses that have again joined us on this case. Do you want to coordinate with them and see if they would be available on the afternoon of the 17th?
Señor Donnelly, también veo que usted tiene Señor Donnelly, veo que usted también tiene testigos previstos para ese día. Quería coordinarlos con ellos para el día 17 a partir de las 2 de la tarde.
She's in the Teams meeting. Would you like me to just ask her now? Or?
Yes.
Ms. Bermudez, can you hear me?
I do not see Ms. Bermudez anymore. I see Ms. Reynoso.
She stepped out, Peter.
Okay. Judge, I anticipate that's going to work. She's been available at all times, so I think we can set it for then, and I'll give her a call and let her know.
All right.
And Your Honor, is the defendant going to be transported from the jail to the courtroom that day?
Ese día el acusado va a ser transportado desde la cárcel hasta el tribunal.
Absent some change in circumstance that I am not anticipating, yes.
Si no hay ningún cambio en las circunstancias al cual yo esté advertido, creo que sí.
Okay, so I'll have his parents there in the courtroom as well on the 17th at 2 p.m. and I'll meet with the defendant prior to, the holding room. That way I can go over the plea form.
Bien, entonces tendremos a sus padres presentes el día 17 dentro del tribunal a las 2 de la tarde y antes de eso, pues yo me reuniré con mi cliente.
Ms. Minyarji Singh, if you will remind Ms. Hafner that this gentleman will need an interpreter and provide a list of your anticipated witnesses so they won't have any issues in getting entry into the courthouse.
Licenciada, usted se ocupa de que va a haber un intérprete y de una lista de sus testigos para que no haya más demoras.
I'll file a witness list, Your Honor, and I will, as far as interpreter with your JA, file notice of hearing.
Señoría, me encargaré de todos los detalles, tanto del intérprete como los testigos.
All right, sorry for the false start today. Thank you. We'll readdress this case on the afternoon of February 17th, next Wednesday, around 2 o'clock.
Muy bien, gracias a todos. Les pido disculpas por no poder proceder, pero les veremos el día 17 por la tarde a las 2.
Thank you.
Gracias.
Sir, we will see you in 1 week.
Señor, le veremos en una semana.
Gracias, señor.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
All right, the next case that I had was Mr. Ortiz Gilby. Mr. Mills is present at the jail facility. Morning, Mr. Mills.
Good morning, sir.
Thanks for your patience.
Oh, no problem. My client also requires an interpreter if he's still on the line.
Mr. Interpreter, are you still with us?
I'm here with you, Your Honor.
Thank you. You mind another case in 2020 CF 1294, Ortiz Gilby, and you would be doing the interpreting again over the intercom system.
Absolutely, Your Honor.
All right.
Your Honor, the state's going to reach out to Ms. Demers real quick because I think she bounced to another courtroom. This is her case, I believe.
I'm here, Mr. Collins. Thank you.
She's physically with me, Mr. Collins.
I apologize, Your Honor. I just didn't see her in Teams.
Not a problem. Appreciate it.
I appreciate it too. I've been running around all morning.
All right, we are here on a motion to reduce bond. I have reviewed the motion indicating that the defendant is currently being held without a bond. Does the state of Florida intend to show proof is evident, presumption great?
Yes, Your
Estamos
Honor.
aquí en una petición para reducir la fianza. He revisado la solicitud ya que en el momento el acusado está siendo retenido sin fianza. La Fiscalía de Florida, ¿qué piensa de esto?
All right. Pursuant to the Arthur analysis, the state has the burden of production. The court may consider affidavits. Are you intending to present any witnesses or testimony?
Después de revisar toda la documentación y los análisis, la Fiscalía tiene la posibilidad de solicitar o reducir la fianza. ¿Desean ustedes presentar cualquier tipo de prueba o testimonio?
Lauren Demers on behalf of the state. Your Honor, the state does intend to move forward under the Arthur standards. I do not have any live witness testimony. I do have a series of affidavits to provide to the court.
Su señoría, la señorita Demers representando la Fiscalía de Florida y después del análisis de la ley del estatuto Arthur, no tenemos testigos en vivo, presenciales, pero sí tenemos declaraciones juradas.
The state did submit via email to Mr. Mills yesterday a condensed PDF with all of the exhibits.
La Fiscalía sí le entregó al señor Mills, pues todos los formatos de declaraciones a través de formato PDF.
And I do have them for the court this morning as well.
Y también las tengo para su señoría al mismo tiempo.
Do you have any victims that are appearing remotely, Ms. Demers?
Señorita Demers, ¿tiene usted alguna de las víctimas que van a comparecer por remoto?
No, Your Honor.
No, su señoría.
And just to clarify with Mr. Mills, before I move forward with the introduction of all of the affidavits, because each affidavit is marked by the clerk, was there any objections that we need to argue before I do so?
Y antes de proceder adelante con el señor Mills sobre las declaraciones juradas que están ya marcadas por la Secretaría, por la actuaria, ¿alguna protesta u objeción por parte de la defensa?
I do not object, and I have all the documents here with me as well.
No tengo ninguna objeción y tengo todos los documentos presentes conmigo.
So at this time, Your Honor, the state has multiple affidavits identified as A through J. They're each a composite exhibit of a series of reports, statements, and the score sheet. Would Your Honor prefer I go through each one in turn?
Please.
Y su señoría, ya en este momento, si la Fiscalía tiene un número de declaraciones juradas que están marcados entre la letra A hasta la J, son informes, son declaraciones y también la tabla de puntuación.
So first, the state would move what has been previously marked as State's Composite A into evidence as State's 1. This is the arrest affidavit filed by Officer Keith Arsenault with the Kissimmee Police Department.
La primera es la informe policial de su arresto, que la Fiscalía desea que se marque como número 1 de las pruebas, y esto es el informe policial de su arresto por el oficial Arson de Kissimmee.
And I provided that back to Madam Clerk.
Right, without objection, that will be received as States 1.
No hay ninguna protesta y se acepta como de prueba de la Fiscalía número 1.
At this time, State would move what's been previously marked as State's Exhibit B into evidence as State's Composite 2. This is 2 sworn statements and their translations from victims Elizabeth Vega, her sworn statement in Spanish, as well as the translation, as well as the sworn statement from victim Jerry Velez Mendez, written in Spanish, and also the translation. That will be introduced as States 2.
La segunda que tenemos está marcado con la letra B, es el documento de prueba que la Fiscalía somete, solicitamos que sea con el número 2, y estos son 2 declaraciones juradas escritas en español y sus traducciones de las víctimas. La primera es de Elizabeth Velez y la otra del otro señor, que están escritas en español y traducidas al inglés.
Without objection, that will be received as States 2.
Prueba de la Fiscalía número 2.
Next, Your Honor, I have State's Exhibit C. This is a sworn law enforcement affidavit by Officer Kolosnik. The state would move at this time to introduce this into evidence as States 3.
Después tenemos la declaración jurado del oficial Kolosnik, que solicitamos que sea prueba número 3.
Without objection, that will be received as States 3.
Se acepta como número 3 de la Fiscalía.
Next, Your Honor, State has State's Exhibit D for identification. This is a sworn law enforcement report from Officer Toro. The state would seek to move this into evidence as States 4.
La siguiente es la letra D. Esto es una declaración jurada por parte del oficial de policía Torres y la Fiscalía solicita el número 4.
Without objection, that will be received as States 4.
Se admite como la Fiscalía prueba número 4.
Next, Your Honor, is State's Exhibit E for identification. This is a arrest report, supplemental report from Detective Salgado with the Kissimmee Police Department. The state would move this into evidence as States 5.
El siguiente está identificado con la letra E. Esto es el informe del arresto. Está escrito por el detective Salgado del Departamento de Policía de Kissimmee y solicitamos que sea aceptada con el número 5.
Without objection, that will be received as States Exhibit 5.
Prueba de la Fiscalía número 5, aceptado.
Next, Your Honor, is State's Exhibit F for identification. This is a supplemental report by Detective Morris with the KPD, with the Kissimmee Police Department. The state moves what's been marked as States F into evidence as States 6.
El siguiente es la letra F. Esto es un informe adicional escrito por el detective Morris del Departamento de Policía de Kissimmee y solicitamos que sea aceptado con el número 6.
Without objection, that will be received as State's Exhibit 6.
Eso se recibe sin ninguna objeción como prueba de la Fiscalía número 6.
Next, Your Honor, is State's G for identification. This is a CPT forensic interview report from the child by the first name Jesden Gartier, who was interviewed in reference to this case. The state would move what's been marked as State's G into evidence as State 7.
El siguiente está con la letra G, es un informe del forense sobre una entrevista con el menor, Jesse Gardick, y es una entrevista número 6 que deseamos que sea admitido con el identificado con el número 7.
That will be received as State 7 without objection.
Ninguna protesta, se acepta como la Fiscalía número 7.
Next, Your Honor, is State's Exhibit H for identification. This is a CPT forensic interview report of Maya Gautier. State would move this into evidence at this time as State's 8.
El siguiente es una entrevista con la señorita Maya Gautier y la Fiscalía desea que se reciba y se marque con el número 8.
State's Exhibit 8 will be marked without objection.
Número 8, sin ninguna protesta por las partes.
And then finally, Your Honor, is State's Exhibit I for identification. This is the specialized interview report of the victim Daliachi Gartier Cruz. The state is seeking to move this into evidence as State's 9.
Y por último, la letra I, que es un informe de la entrevista especial del señor Daliachi Gautier y solicitamos que sea aceptado con el número 9.
Be received as State's 9 without objection.
Número 9 de la Fiscalía, sin ninguna protesta.
And then, Your Honor, the last thing for consideration, not necessarily to put into evidence, but is a copy of the defendant's score sheet.
Por último, su señoría, no es para que sea admitido, pero es la tablilla de puntuación del acusado.
Thank you.
And that would be everything that the state has in reference to sworn affidavits for consideration of the Arthur predicates this morning, Your Honor.
Y eso es todo lo que la Fiscalía presente en cuestión de sus pruebas para lo que es la causa Arthur.
All right, as to the Arthur portion of the hearing, Mr. Mills, do you wish to present any evidence or testimony?
Y en cuanto a la parte expediente del análisis de Arthur, el señor Mills desea presentar cualquier tipo de pruebas o testimonio.
I would just note that the victim has signed a declination that has been provided to the state, and that would only be the victim of the attempted murder and kidnapping charge. Other than that, there's no other evidence to offer at this time, Your Honor.
Solo queremos presentar una declaración de la víctima firmada que fue presentado al Estado sobre la acusación de asesinato y secuestro.
Which? The declination. That's not in the court file.
All right, thank you. Are you asking that the court take judicial notice of the declination of prosecution?
I believe it should be in the court file, yes, Your Honor.
Usted está pidiendo que este tribunal toma notificación judicial de la declinación por parte de la víctima. Sí, su señoría debe de estar dentro del expediente.
All right, that is not contained within the court file. I'm being informed by Madam Clerk.
Eso no está dentro del expediente, me lo acaba de decir la señora actuaria. Bien, su señoría.
State argument as to whether the state of Florida's affidavits have proven that proof is evident, presumption great, that Mr. Ortiz Gilbey committed the offense charged in the information.
La Fiscalía de Florida ha presentado las declaraciones juradas en el cual queda demostrado que el señor Ortiz Gilbey pues tiene bastante presunción.
Yes, Your Honor. It is the state's position that we have met our burden under the Arthur standard.
Sí, su señoría. Da parte de la fiscalía que hemos podido demostrar según peso de las pruebas, según el estándar Arthur en esta causa.
I know Your Honor hasn't had a chance to review all of the documentation yet.
Sé que su señoría no ha tenido la oportunidad de revisar toda la documentación presentada en este momento.
However, contained in all of the documentation is a very consistent version of what occurred that night.
Pero hay dentro de la información una relación muy detallada de todo lo que ocurrió esa noche.
There are multiple accounts from the victim, Ms. Daliacha Gartier Ortiz.
Hay múltiples referencias de la víctima, la señora Daliachi Ortiz.
Contained in a sworn interview with law enforcement as well as CPT.
En una entrevista bajo juramento con las autoridades y la policía.
These statements line up also with the sworn statements of the other two victims in this case, Ms. Vega and Mr. Velez Mendez.
Estas declaraciones concuerdan con las otras dos víctimas, la señorita Vega y el señor Velez Mendez.
Which also is corroborated by the children's statements that were made to CPT.
Y también esto concuerda perfectamente con las declaraciones que hicieron los niños, en este caso a CPT.
And I do want to advise the court that the reason the state did not play the interviews today is because they are in Spanish.
Y también la Fiscalía quisiera decirle a su señoría que el motivo por el cual no hemos puesto esas entrevistas hoy es porque están en español.
And we're still in the process of getting those transcribed for both myself, defense, and a potential trial in this matter.
Y está todo en el proceso de ser traducido por un intérprete forense para lo que son las audiencias previas y potencialmente o supuestamente un juicio oral.
However, based on all of the information contained in the affidavits, it's the state's position that the proof is evident and the presumption is great, although it is an or, that the defendant committed both attempted murder with a weapon as well as burglary with a battery.
Pero basándonos en las declaraciones juradas, vemos que hemos llegado al peso de las pruebas y que la presunción de inocencia, bueno, es un poco débil, así que queda demostrado que el acusado hizo el intento de asesinato, así como el robo con agresión.
This bond hearing and the Arthur standards do apply to both counts 1 and 2 of the information.
Lo que son los estándares Arthur y todas las previas antes sí concuerdan con la acusación en 1 y 2.
And in summary of all of those affidavits, the proof is evident that the defendant in this case did stab the victim, Ms. Daliachi, multiple times, make multiple statements about killing her, her fear of being killed, as well as make entry into the neighbor's home.
Y según las declaraciones juradas, queda más que demostrado que el acusado apuñaló a la señorita Del VOP múltiples veces, también la amenazó con matarla múltiples veces, dando eso a un temor por su vida y entrando en casa de los vecinos.
And it's the state's position that contained in all of the affidavits is more than enough evidence to prove either that the proof is evident or the presumption great in this matter.
Y la Fiscalía, basándose en todas las declaraciones juradas, ve que la presunción de inocencia pues es muy débil y que hay bastante peso para acogernos a esas declaraciones.
So the state would request that the defendant be held on no bond for both counts 1 and 2.
Así que la Fiscalía está solicitando que el acusado sea retenido en la cárcel sin posibilidad de fianza, presión preventiva en las acusaciones 1 y 2.
Any other argument as to the Arthur portion of the bond hearing, Mr. Mills?
Yes.
Señor Mills, alegatos sobre la porción Arthur en el expediente.
As to the burglary with a battery, the victim's statement, you will note, when it is translated, indicates that he came in the house and the male owner of that house took him out by force. I don't think, if I'm reading it correctly, the translation indicates that a battery occurred, according to Mr. Velez Mendez.
Bueno, sí, señoría, en cuanto a la acusación de lo que es robo mediante el uso de la fuerza y agresión, si vemos en la declaración de la víctima y su traducción, cuando el señor entra en la casa, el ocupante o propietario varón de la casa lo sacó por la fuerza, sin que hubiera habido ninguna agresión. Eso según, si lo leo correcto, en la traducción.
With regard to the attempted murder and kidnapping counts, the evidence, I believe, is conflicting in that, well, there is some indication that the victim, at least initially, started the altercation by hitting him and slapping him, and at one point even, I believe, kicked him in his genital area.
En cuanto a la acusación por el asesinato y secuestro, pues vemos que hay algunas pruebas que no concuerdan, ya que tenemos nosotros visto que la víctima fue la que empezó la confrontación inicial, empezando por pegarle, abofetearle y dándole una patada en sus partes genitales.
I don't believe the children corroborate the victim's account of what happened when the victim alleges that my client pushed her down and was stabbing her, yelling, "I'm going to kill you."
Y no creemos que la versión de los niños puede corroborar la declaración de la víctima cuando dice que mi cliente la empujó en el suelo y la estaba apuñalando diciendo, te voy a matar.
Many of the victim's injuries were suffered as they struggled, from what I gather, on the floor of the home as they struggled over the knife. And I would note that the knife was brought into the altercation by one of the children, and the struggle ensued over the knife at that time.
Muchas de las lesiones y heridas sufridas por parte de las víctimas, eso fue cuando estaban en el forcejeo, en el suelo, que estaban forcejeando por el cuchillo. Y ese cuchillo fue introducido en la habitación por uno de los niños, de ahí la raíz de tantas lesiones.
I don't have any further argument at this time, Your Honor. Thank you.
En este momento no tenemos más alegatos.
Thank you, Mr. Mills. Court is, as to the Arthur portion of this hearing, going to issue a written ruling after my review of the affidavits, and I will consider defense's argument that the evidence is conflicting as to counts 1 and 3. The injury sustained, it is purported, occurred during a struggle. There is purportedly a declination of prosecution filed by at least one of the victims, and that there is a factual dispute as to whether there was a battery committed during the process of the burglary as to count 2. I'll resolve those issues and issue a written ruling regarding the Arthur factors.
And if Your Honor,
Este tribunal, después de escuchar la parte Arthur del expediente, hará su veredicto por escrito, revisar lo que es la declaración jurada. Vemos que hay algunas cosas que son un poco contradictorias en las pruebas a favor del defendido en las acusaciones del 1 al 3, donde las lesiones fueron producidas por el forcejeo, y también hay una declinación firmada por una de las víctimas en cuanto a la agresión en la acusación número 2.
just for clarification of the record, the kidnapping is charged as an attempted kidnapping, so he would be entitled to bond on that count.
Solo para aclarar una cosa, en las acusaciones, la acusación de secuestro es intento de secuestro, y el acusado sí podría pagar la fianza, o se establecería fianza en esa acusación.
And additionally, I do not believe, since the declination is not in the court file, and the state would argue it cannot be considered, it hasn't been introduced into evidence, and is not relevant as it relates to the Arthur portion of the bond hearing.
Y también eso, como no ha sido introducido como parte de las pruebas, pues no se puede incluir en la porción del expediente Arthur en esta causa.
Nothing further.
No más, su señoría, nada más.
Mr. Mills, if the court determines that the Arthur standard has been met, the court can still consider bond in this case. Do you wish to present any testimony as to ability to post bond?
Yes, Your Honor. I'll have my client testify briefly.
Hold on just a
Su señoría, si este tribunal determina que se ha cumplido lo que es la parte de Arthur Standard y puede establecer una fianza, quisiera usted, señor Mills, presentar cualquier tipo de testimonio. Su señoría, quisiéramos que brevemente mi cliente pudiera testificar.
Let's swear in. Did we already swear in
We haven't.
Mr. Ortiz Gilde?
Please raise your right hand.
Señor Ortiz, levante la mano derecha.
Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Usted jura y afirma que el testimonio que dará concernientes a esta causa será la verdad, toda la verdad y nada más que la verdad, con la ayuda de Dios. Yes.
Sir, you can put your hand down.
Puede bajar la mano.
Where would you be living if you were going to be released on bond?
Señor, si usted se le pone en libertad bajo fianza, ¿dónde viviría usted?
Aquí en Florida.
Here in Florida.
With who?
¿Con quién?
Con una amiga.
With a friend.
What's the friend's name?
¿Cuál es el nombre?
Marielis.
María Liz.
No, Marielis.
María Ellis.
Is that here in Osceola County or someplace else?
¿Eso es aquí en el condado de Osceola o en algún otro sitio, señor?
En Orlando.
En Orlando.
Who would be posting the bond for you?
¿Quién pagaría la fianza por usted, señor?
Marielis.
María Ellis.
If the court were to set bond at somewhere between about $10,000 or $20,000, do you think that she could come up with the amount of money necessary to bond you out?
Si este tribunal fija una fianza entre, digamos, los $10,000 y los $20,000, ¿usted cree que ella puede reunir esa cantidad de dinero para que usted salga bajo fianza?
Sí.
Yes.
What type of work would you try to do if you were released?
¿Qué tipo de trabajo intentaría hacer usted si es que fuese puesta en libertad?
Bueno, construcción o volver atrás al trabajo que tenía de ceiling matres.
Construction, or I would try to go back to my old job of ceiling mattress.
Do you have any money in any bank accounts?
¿Tiene usted cualquier dinero en cuentas bancarias ahora mismo?
No.
No.
What type of work does Maria do?
¿Qué tipo de trabajo hace María Ellis?
Ella hace uña.
She works in a nail salon.
Do you have any idea how much money she makes?
¿Usted tiene idea? ¿Tiene idea de cuánto dinero gana ella?
No.
No.
Would family members also be willing to help post your bond?
¿Miembros de la familia también estarían dispuestos a ayudar en el pago de su fianza?
Sí, mi hermano y mi amigo.
Yes, my brother and my friend.
Do you have family members who live in Puerto Rico?
¿Usted tiene miembros de su familia que viven en Puerto Rico?
Sí.
Yes.
But you will stay within the state of Florida until your case is resolved, correct?
Pero usted se quedaría dentro del estado de Florida hasta que su causa sea resuelta por completo.
Sí.
Yes.
How long have you lived in the state of Florida for prior to your arrest?
Antes de su arresto, ¿por cuánto tiempo ha vivido usted en el estado de Florida?
Como 2 años y medio.
2.5 years, more or less.
Thank you. I don't have any further questions, Your Honor.
No hay más preguntas, su señoría.
Mr. Burns, any questions?
Fiscalía.
Yes, Your Honor. Mr. Ortiz, what is your relationship with Maria? And I don't know, I couldn't make out the last name.
A ver, señor Ortiz, ¿cuál es su relación con la señorita María? No sabido cuál es su apellido. ¿Cuál es su relación con ella?
Con Marielis.
With Maria Liz?
Yes.
Sí.
Somos amigos.
We are friends.
Do you have a job lined up at this time if you were to be released?
¿Usted tiene un trabajo ya esperándole si es que usted saliera libre?
Bueno, puedo tener uno instalando granito.
Let me see, I could have one installing granite countertops.
And how many of your family members live in Central Florida?
¿Cuántos de sus relaciones familiares viven aquí en el centro de Florida?
Bueno, contando los familiares de la mamá de mis hijos o contando mi familia nada más.
Do you want me to count only my family or also the family of the mother of my children?
Just your family, please.
Solo su familia, por favor.
2 personas.
2 people.
Is the majority of your family in Puerto Rico?
La mayoría de su familia vive en Puerto Rico.
Sí.
Yes.
Prior to this incident, were you on probation from Puerto Rico?
Antes de este incidente, ¿usted estaba en régimen probatorio desde Puerto Rico?
Sí.
Yes.
No further questions.
No hay más preguntas.
Thank you. All right, the court has made notes regarding the testimony of the defendant's ties to the community and financial ability to post bond.
Este tribunal ha tomado notas del testimonio del acusado, de sus las ataduras, o sea, las conexiones que él tiene con la comunidad y con su familia.
Court will issue a written ruling within 3 business days.
Tendremos el fallo por escrito dentro de 3 días.
Your Honor, may I just add one more thing?
Quickly.
With the, he's on federal probation out of Puerto Rico. The state and I think defense as well are still trying to figure out if he were to post bond, what that means, if he'll be transported back to Puerto Rico, things of that nature. But it is my understanding that he is actively on federal supervision for that case reflected on the score sheet.
Su señoría, la fiscalía quisiera añadir que el acusado está en libertad de régimen libertad probatorio federal desde Puerto Rico. La fiscalía y la defensa están intentando ver si él pusiera la fianza, si sería transportado otra vez a Puerto Rico o no, ya que está bajo la supervisión federal.
Thank you. Mr. Mills, I know you've been out there a long time. I have a hearing that is scheduled for 11:30 with a number of observers. I need to address that case.
Okay.
Thank you.
Yes, sir.
I'll get to you as soon as I can.
Thanks, Judge, I appreciate it.
Good morning, Ms. Espinal. Can you hear me?
Yes, I can.
All right, thank you. We have a number of news outlets as well as a number of telephone numbers and some names that I do not recognize. Do you see the Office of the Public Defender in any of these names?
Your Honor, I'm sorry to interrupt. May the interpreter be excused?
I apologize. Thank you very much for your help this morning.
Thank you, Your Honor. Thank you to the staff.
Your Honor, items online, I can make sure that they log back in.
All right, thank you.
Judge, and I will let you know that Cindy Kopko is the victim's family member.
All right, thank you. I'll be admitting all of these folks, and then we will All right, I'm going to start admitting members of the media here. All right, we have the attorneys are physically present in court. Let me start admitting some of the observers. All right, good morning. This is Judge Karsten. I know that we have a number of observers and media outlets that are joining us for the status hearing today on Anthony John Tott, 2020 CF 149. Present online is Ms. Pinnell with the Office of the State Attorney. Physically present is Ms. Cobb and Mr. Schmer on behalf of Mr. Tott. Mr. Tott is at the Osceola County Jail facility. Pursuant to our Chief Judge's administrative order, there are no in-person hearings at this point. Mr. Schmer, Ms. Cobb, is the defense wishing to move forward with Mr. Tott's appearance on video, or would you request a reset of this status hearing until after February 15th?
Mr. Todd is present. I'll leave it up to him. I mean, we do consult with him regularly. Mr. Todd, do you want to be present in the courtroom, or is this virtual hearing fine with you? I guess he can't hear us.
If you would, Mr. Schmer, if you would get near one of the gooseneck microphones, that will assist him in hearing you a little better.
Tony, His Honor asked us, do you wish to be present physically in the courtroom, or is this virtual hearing acceptable to you?
This is fine.
Okay.
All right, thank you. We've also note that the court reporter is present, but they are appearing remotely as well. Does the state or defense request the physical presence of the court reporter, or are you satisfied with the recording?
Technically, I believe that there's a Supreme Court order mandating that a live court reporter be present for first-degree murder cases.
All right. They are live and physically present downstairs, but if you're requesting their appearance here in court, then I will make a call and ask them to come up to the courtroom.
As long as the court reporting in real time versus listening to a transcript or an audio recording.
All right. Madam Clerk, would you have Ms. Hafner call court reporting and verify that there is a physical court reporter transcribing these events? All right, it's being represented based on our representations downstairs that this is being live reported. So is that arrangement acceptable with the defense?
That's fine, Judge.
Thank you. Right, this is 2020 CF 149, the state of Florida versus Anthony John Tott. This is set for a status hearing. The case has been reassigned to this division. I have reviewed the court file and are familiar with the procedural background of this case. The court is seeking guidance from the attorneys as to when this case should be ready to either set for trial or set for some other track. Mr. Schmer?
Judge, I can just fill you in. The main depositions have already been done. The main depositions were on the two medical examiners, one of whom replaced the other one who went on a cross-country journey, I guess, for lack of a better term. And the lead detective was deposed back in October. So we really have only 6 more depositions to go. Those are resets from an October deposition schedule that did not go through. We had a snafu with the court reporter. So they're being I've asked the secretary to schedule those 6 depositions. They're mostly on crime scene technicians. We also have to have an evidence viewing. The state had wanted us to itemize the list of exhibits we wanted to look at. There are lots of them, but then that needs to be done. What I'm suggesting to the court, that you set a status hearing in a couple of months, and I'll give you the timeline if I may. The other issue is there will be a motion to suppress filed on Mr. Toth's behalf. I should have that filed. I think I'll be handling it at the end of February. So in about, within 3 weeks, I'll be filing it. I would ask the court to set another status hearing. As far as when the trial is ready to be tried or a trial date, Mr. Wesley and I talked about it on the phone yesterday. He thinks, and I concur, that a summer trial date would be appropriate.
Thank you. Ms. Pinnell?
Judge, I believe that I heard the defense indicating that it's only a summer trial date.
That was what was...
I'm going to be unavailable over the summer. I intend to file a notice of unavailability for a period of a couple months over the summer. There are some discovery depositions. I don't have any objection to setting the case for a status hearing in the next few months, see exactly where we are in line for trial.
Can I have the current court inquire Ms. Pinnell what period of time she foresees being unavailable?
I anticipate being unavailable from June through August.
Okay. And I personally would not be able to try this case anytime before June. I can explain to the court why. Maybe if we go off record, I don't want to disclose personal things.
All right, based on Ms. Pinnell's unavailability, based on the fact that discovery appears to be ongoing, based on the unavailability of the defense prior to June, it appears the trial date sometime in late August, early September, or October seems to be a reasonable expectation. Ms. Pinnell?
Judge, I would request October just to be on the safe side, or late September.
Mr. Schmer, Ms. Cobb?
As soon as possible, when the attorneys are available.
All right. It appears that some additional work needs to be done on the case by the attorneys. I am inclined to set this on the September 27th through October 15th trial period. The pretrial for this case would be on September 15th. The court will anticipate that all pretrial motions and discovery will be completed by that time. If there's any delays that the court needs to intervene in, please bring those to the court's attention, and I will try and resolve matters as they occur. Ms. Pinnell, have you discussed the October trial date with any potential witnesses?
I have not, Judge.
All right, if you will coordinate that date with your potential witnesses and let the court know as soon as possible as to any known conflicts. Mr. Schmer, I will ask that the defense does the same, then the anticipated witnesses in the case. Right. Ms. Pinnell, the court in a review of the court documents indicated or saw that in 2020 CF 149, there was a notice of intent to seek the penalty of death as to each of the victims, Zoe, Tot, Alexander, Tot, Tyler, Tot, and Megan, Tot. The court received a one-page document from our previous elected state attorney, Ms. Aramis D. Ayala, indicating the state's notice of intention not to seek the death penalty. It does not reference the individual notices of each counts 1 through 4. Is it your understanding that this notice of intention not to seek the death penalty applies to each counts 1 through 4?
That is what I believe the intent was, Judge.
All right, thank you. State, is there anything that the court can do to help facilitate a realistic trial period in late September, early October?
No, Judge.
Mr. Schmer, anything the court can be doing at this point to help ensure that that's a realistic expectation?
No, Judge.
All right, thanks. When can the court anticipate some pretrial motions?
Again, the motion to suppress should be filed at the end of the month. Then there will be some various motions to eliminate filed afterwards.
Thank you. As soon as those motions are filed, if you will coordinate appropriate hearing time with Ms. Pinnell and Ms. Hafner, we'll get those motions addressed. Is there anything further from any party?
No, Your Honor.
Ms. Pinnell?
Nothing for this date, Judge.
Thank you. That will conclude our hearing.
Thank you.
All the witnesses, all the observers on behalf of Mr. Tott's case, feel free to disconnect. All right, we are going to go back to our docket. Mr. Mills, are you ready on your case? Mr. Mills, I see that you have a plea anticipated on Stephen Dunn.
Yes, sir.
Morning, Mr. Dunn.
Good morning.
I have a signed plea form here by Mr. Dunn that includes his Osceola and Polk County VOP cases, Your Honor.
Thank you.
Anna Rivera on behalf of the state, Your Honor.
Thank you. Mr. Dunn, we're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm the testimony you give to this court is the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Mr. Mills, I don't have the plea form. If you could run me through the anticipated sanctions.
Yes, Your Honor. Mr. Dunn would enter an admission to the violations of probation in each of the 4 cases. As to the Polk County cases, the agreement is 90 days in the county jail, which he has credit for more than that at this point in time, followed by reinstatement to his original term of probation, and restitution is to be paid at a minimum of $400 per month moving forward. As to his Osceola County VOP in case 18-4283, it would be time served followed by reinstatement with an additional year of supervision with the original terms and conditions, Your Honor.
Is that a new period of 12 months, or is it a reinstate with an additional 12
I
months?
think it would be a modification with an additional 12 months.
Yes, Your Honor.
At the state's intent? All right, thanks. Mr. Dunn, Mr. Mills is holding a bunch of documents. Those are admission to violation of probation forms. Have you had a chance to review and go over those documents with Mr. Mills?
Yes, Your Honor.
Did you read and understand them?
Yes, Your Honor.
What those documents tell me is that you wish to admit that you have violated probation in 2018 CF 4283 for the reasons alleged in the affidavit of violation of probation. Is that what you wish to do?
Yes, Your Honor.
And in Polk County cases 2018 CF 3139, 2018 CF 3140, and 2018 CF 3141, those documents indicate that you wish to admit that you violated probation in those cases for the reasons alleged by your probation officer. Is that correct?
Yes, Your Honor.
In each of these matters, do you understand that you have a right to have a violation of probation hearing? At the hearing, the state of Florida would have to prove to me, to the court, by a preponderance. That means a greater weight of the evidence that you had violated your probation in a material and willful way. At that hearing, Mr. Mills would have been with you, would have cross-examined witnesses and examined the evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, could have asked me to make them come to court with a subpoena. You could have participated in the hearing, had it recorded, and appealed any error that occurred in that process. Do you understand you are giving up all of your hearing rights because if the court accepts these admissions? I'm going to go along with the agreement that Mr. Mills just told me, and we are not going to be having a hearing in any of these matters. Do you understand all that?
Yes, Your Honor.
Is anyone forcing you or pressuring you into making this decision?
No, Your Honor.
Has anyone made you any promises other than what is written on your admission forms and what was represented by Mr. Mills?
No, Your Honor.
Are you under the influence of any alcohol, any drugs, any mental issues that cause you not to understand the decision that you're making?
No, Your Honor.
Do you understand if you are not a United States citizen, entry of these admissions would cause you to be deported?
Yes, Your Honor.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of these admissions could cause you to be involuntarily civilly committed. Do you understand that?
Yes, Your Honor.
Mr. Mills, is the defense stipulating to factual bases for purposes of the admission?
Yes, Your Honor.
Court accepts those admissions, find that Mr. Dunn appears to be alert, intelligent. He's had an opportunity to think about this decision and discuss it with Mr. Mills. You satisfied with Mr. Mills' help?
Yes, Your Honor.
You've indicated to me no one has forced you or pressured you into making this decision, and you do so of your own free will. Court will accept your admissions that you had violated probation in our case, 2018 CF 4283, and also in the Polk County cases, 183139, 183140, and 18 CF 3141. As to our case, you will be adjudicated guilty of the underlying offense if you were not previously adjudicated. You're going to get credit for the time that you have already served in our jail.
Do they want the full time or just the violation of
Just be from the
probation?
violation.
122 days?
So you get credit for 122 days. You are reinstated to the original terms and conditions of your probation with the added sanction that you will complete an additional 12 months. Any costs that you previously owed, you will remain owing. You'll need to report to a probation officer within 24 hours of your release. As to the Polk County cases, each case concurrently and concurrent with our case, you will be sentenced to 90 days in the jail. Court will accept your admission. You will be reinstated to the original terms and conditions of those probations. You are ordered as a condition of probation to make restitution payments. Is that in all three cases, Mr. Mills, or is that in a specific case?
It would be 400 total for all three.
All right. You will make restitution at a minimum amount of $400 for cases 2018 CF 3139, 3140, and 3141 in the aggregate, meaning all together. You'll need to report to your probation officer within 24 hours of your release, and we'll give you credit for the time that you have already served in those three cases.
Violation of probation time, only 120 days, so the 90.
So we'll give you credit for 120 days as to each case, so that jail sentence portion has been satisfied. As to the cost, you still owe the cost in each of those cases. Any money that you pay shall go to restitution first at that minimum amount of $400 per month. As to all four cases, you will have 30 days from today's date to appeal the judgment and send it to the court. If you wish to do so, you must do it in writing. If you can't afford an attorney, one will be appointed for you. Those sentences will run concurrently, meaning at the same time as to each case. Madam Clerk?
I'm a little bit confused on how you want me to word the restitution with the three cases for Polk.
The agreement with Polk County was that he's to pay $400 minimum restitution for all three cases. I guess he's got the same probation officer, and I don't know how they're going to allocate that.
Would it be okay to put 400 in the one case and then leave it out on the other two?
Yeah, the agreement is causing the clerk some difficulty in formulating the court minutes.
I have no idea what 400 divided by 3 is, but perhaps it would make sense so all those victims could start getting paid at the same time to do it that way.
Okay, I'll just do like a weird number, but $133.33. It's as close to 400.
All right. So the agreement will be that the payments will be made at a minimum rate of $133.33. If restitution is paid off in any one case, that money needs to be split between the remaining cases to total $400. All right, Mr. Dunn, as to these cases, it appears that you should be released. And do not forget to check in with probation. Is he being placed on probation out of Osceola County? So does he need to report here? I think he will need to report here. I have no objection to this being transferred to Polk County if that's where he lives. Where's Mr. Dunn live?
I live in Osceola County.
All right, thanks. So report to the Osceola County probation office within 24 hours of your release. Anything further, Mr. Mills?
No, Your Honor. Thank you.
Anything further, State?
Nothing from the state, Your Honor.
Anything further, Ms. Butler?
No, Your Honor.
All right, good luck to you. Thanks.
Thank you, Judge. Have a good day.
You as well.
And that's all I have, Your Honor. May I be excused?
Of course, thanks. Mr. Merce, do you have Navarros Rodriguez?
Yes, I do, Your
All
Honor.
right, and who has Matthew Houts?
Your Honor, Mr. House is in contact isolation. If you'd like him, we can bring him up once the courtroom is clear.
Okay, who's not able to be with us?
House, he's in contact isolation. If you'd like him to come up, we need to clear the courtroom. He's in contact isolation.
All right, thanks. Mr. Prey, Mr. Collins, I'll have to take Mr. Houts last.
That's fine.
Sorry about that.
No problem.
Are we ready to move forward on Mr. Navarros Rodriguez? Does Ms.
Ready, Your Honor.
And who is defense? Ms. Jimenez, does Mr. Navarros Rodriguez need the assistance of an interpreter?
No, Your Honor.
Thanks. All right, let's swear in Mr. Navarros Rodriguez.
Please raise your right hand. Thank you. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, for the record, every minutes on behalf of Mr. Navarros, S. 21 CF 4. Defense filed a motion for reduction of bond, and we would like to ask the state's position for this. We were not able to include the state position.
Lauren Demers on behalf of the state. Your Honor, the state would object.
All right, thanks. The state is in objection to a reduction of bond. I do have a copy of the motion. I have reviewed it. Ms. Jimenez, do you wish to present any witnesses or evidence?
Yes, Your Honor, if I would like to call my client.
Thank you. Mr. Navarros Rodriguez, I believe we've sworn you in. I'm going to point Ms. Jimenez over so that she can view you. Ms. Jimenez, whenever you are ready.
Thank you, Your Honor. Can you please state your full name for the record?
Xavier Omar Narvaez Rodriguez.
Do you know how much is the bond pending on your case as of now?
Excuse me?
Do you know what is the amount of bond that you have right now in your case?
9,500.
Okay. Are you able to post that bond?
No, ma'am.
What was your line of employment before you were arrested?
Construction for Franklin Tile and Marble.
If you were to be released on a lower bond and you will be able to post it, will you be able to return to that previous job?
Yes, ma'am.
What would you say will be the estimate average of what you were making before
Excuse me,
you
I can't hear you.
arrested?
Hold on just a sec. Ms. Jimenez, he's having a difficult time hearing you. Get the microphone closer.
Thank you, Your Honor.
Okay, try again.
Can you hear me now, Mr. Navarez?
Yes, ma'am.
Okay. On this employment that you had, which was a company that you were working for?
Franklin Tile and Marble.
How much can you tell the court was your income at that company?
500 a week.
As before the arrest or currently, do you have a bank account?
No, ma'am.
Do you have any savings
No, ma'am.
available to post this bond?
No, ma'am.
If you're released, will you be able to come back to this employment? You say that, right?
Yes, yeah. The job I have is a guaranteed job when I come out.
Your Honor, I couldn't hear the defendant.
If you will repeat your response, sir.
The job that I do have is a guaranteed job when I come out.
Thank you. And do you own any property?
No, ma'am.
Do you own any vehicles?
No, ma'am.
Do you have any piece of land that you can give as a guarantee for your posting your bond?
No, ma'am.
Do you have any collateral or any other assets that you can post as collateral for this bond?
No, I do not.
If you're released and you go back to this employment, how much do you expect to be your paycheck?
500 a week.
Okay. How long have you been living in Florida?
30 years.
Do you have family members here in Central Florida?
Yes, my brother.
Do you have any ties or family members that you can leave besides your brother?
No, ma'am. It's just me and my brother.
Do you have any family ties in Puerto Rico?
I have family, but I don't talk to them. No relation. Yeah, we don't talk.
Do you own a passport?
No, ma'am.
If you were to be released or with a reduction of bond, would you be residing at 4100 Nashville Avenue in Orlando, Florida, 32805?
Yes, ma'am.
Do you know who will be paying for that property?
My brother,
Do you know his name?
Javier Narvaez.
Do you know where he's working?
He works at a granite shop. I don't know the name of the shop.
Do you know the average amount of income that Mr. Narvaez received on his as income in his employment?
I would say 500 a week.
Is your brother able to post the $9,500 bond?
No, ma'am.
Are you asking the court to reduce the bond for a $5,000 bond in total for all the charges?
Yes, ma'am. I would like that very much.
And Mr. Narvaez, do you own a passport?
No, ma'am.
Will you be showing up to any subsequent court proceedings?
Yes, ma'am. I've never missed a court date.
And if the bond is reduced, who will be posting that bond if possible?
My brother.
Thank you, Your Honor. I have no more questions.
Thank you. Mr. Mers, any questions?
The only question I have, Your Honor, is Mr. Navarros Rodriguez, who is it that resides at that Nashville Avenue address?
My brother Javier.
All right, is he the only one that resides there?
Yes, ma'am.
All right, no further questions.
Thank you. Any follow-up questions, Ms. Jimenez?
No, Your Honor.
All right, thank you. Argument?
Yes, Your Honor. My client is currently held on Osceola County Jail pending a $9,500 bond. He has testified to this court that he's not able to post a bond. Based on case law, the defendant has to prove that he's unable and that he's incapable of posting that bond as stated. He testified that his income, it will be based on $500 weekly. He does not have a bank account. He does not have any savings that he can use to post a bond. So understanding that the defense has the burden of producing the evidence of the defendant being able to post a bond on his case, there is no other evidence based on the state. There is no evidence that the defendant can post the $9,500 bond. So the defense will be asking the court to lower the bond for a lower amount. He does not own a passport. His only family member is his brother. He lives here in Orlando. The address was provided to a court. My client wishes to be able to go back to work at this employment so he can be able to provide for his needs and for responding for this case to assist on his defense. And the defense will be asking if, based on the fact that he does not have money to post the $9,500, not owning any collateral or any other piece of property so that he can post through the bondsman for his case, we're asking the court to lower the bond of this case, Your Honor.
Thank you. Mr. Mers?
Yes, Your Honor. The state has provided, I emailed over to Ms. Jimenez earlier today a copy of the score sheet, as well as I provided one to Madam Clerk for Your Honor. And the state would ask that the court take judicial notice of there's 2 arrest affidavits. This case was actually consolidated, 21 CF43 and 21 CF45, consolidating all 5 charges into this case number. I would note that the defendant was originally granted a $1,000 bond on grand theft, one count of grand theft, and the state did not file the grand theft charge. We did file a second-degree misdemeanor of petty theft. So I believe he would be entitled to a bond modification as it relates to that charge, since it's no longer the same. Your Honor, the state is just concerned. The defendant does have a lengthy criminal history, specifically dating back to 2005. He's here today on 2 violent domestic charges as well as some drug and theft charges. He does have a history of multiple convictions for possession of cocaine. He was convicted of a battery at one point. I did reach out to the victim in this case. She advised she did not wish to be present, but she did want the court to know that she is worried about his release and her safety. With any modification, I would ask that the PTR conditions or the special conditions, I don't believe he qualified for PTR, but that those special conditions all remain in place. And just the victim wanted me to let the court know that. But Your Honor, the state thinks besides the grand theft to petty theft being modified, that the bond is appropriate in this case.
Your Honor, if I may add something based on the score sheet of the defendant, he has no failure to appear in his score sheet. I understand that his lengthy history, but there's never have been, as mentioned on the score sheet, a failure to appear for my client to any court proceedings. And that's why I'm asking the court to grant the motion to reduce the bond so he can be able to post the bond and be ready and assist the defense in preparation, and assist counsel in preparation of defense procedures.
All right, thank you. The court is, based on the filing decision of the state of Florida, going to reduce the bond in the grand theft charge to $150, which will now be count 5 of the information. So that bond will be $150. As to a reduction of the robbery charge in count 1 as well as the domestic battery by strangulation, the motion to reduce bond is denied. As to the rest of the counts, the court has considered the considerations pursuant to 903.046. The court finds the nature and circumstances of the offense charged as one of violence, the weight of the evidence against the defendant as sufficient to warrant the bonds as currently set. The court does note that he has an employment history and is a member of our community. The court has considered his financial resources and mental condition as testified to. Court finds that the nature and probability of danger to the community is somewhat elevated based on the allegation of violence and the defendant's lengthy criminal history, as well as the nature and probability of intimidation and danger to the victims is elevated. So beyond the reduction of the uncharged or the count that was charged differently down to $150, the other request to reduce the bond is denied. The total bond at this point should be 7. What's that? Counts 3 and 4 are to remain as, well, what's the bond in count 3?
Your Honor, the possession of cocaine, count 3 was originally modified at IAs and set at $1,000.
Court finds that it's appropriate, and the possession of drug paraphernalia is at $500, and that will remain. So I think the new bonds, based on my math, is going to be $8,650.
Thank you, Your Honor.
Hold on just a sec. We're going to get our math right.
Robberies at 5,000.
Mm-hmm.
The battery is at 500. The possession is
1,000. Paraphernalia is 500.
and then the
150.
So 7,100. Sorry, 7,150.
What was the domestic battery set at?
Your Honor, that one was originally set at only $500.
So the total bond amount is $7,150. With the special conditions as previously announced, no contact with the victim, no return. With it, does he need?
Thank you.
Yep, thank you.
Your Honor, did we arraign him earlier this morning?
We accepted a waiver of arraignment, a plea of not guilty, and he was given court dates.
We haven't given him.
Oh, we're going to give him court
No,
dates
we
now.
haven't.
I was just going to say April 28th, May 10th.
The court dates will be April 28th with a trial period that begins May 10th.
Thank you, Your Honor.
Thank you. That'll conclude your hearing, Mr. Navarros Rodriguez.
So what would be my bond?
It is down to $7,150.
All right, thank you.
Thank you.
Your Honor, we have Mr. Houts present in the courtroom now.
Thank you very much, Madam Correction Officer. Mr. Houts, we'll take Mr. Houts' plea at this time.
Thank you, Your Honor. That's all I have this
Thanks,
morning.
Mr. Mayor.
How you doing, Your Honor?
Good. How are you doing, Mr. Houts? We're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Houts, I'm looking at Ms. Dupre. She is on my computer screen, as well as Mr. Collins. I have a plea form here. It is 4 pages long, has a set of initials after each of the 26 paragraphs, and at the end it has the signature Matthew Houts. Did you have a chance to initial and sign this document?
Yes, I did that yesterday, sir.
What your initial and your signature tell me is that you've actually had a chance to review this document, you've read it, understood it, and gone over all of the information with your attorney. Is that correct?
Yes, sir.
It also tells me that you wish to resolve your case with us this morning by pleading no contest to one count of possession of drug paraphernalia. That is a first-degree misdemeanor. Is that what you wish to do?
Yes, Your Honor.
All first-degree misdemeanors are punishable by up to 12 months of supervised probation, 12 months in jail, or a $1,000 fine. You understand that's the maximum sentence for this type of charge?
Yes, Your Honor.
You understand you have a right to have a jury trial as to this allegation. At the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of the offense that you were charged with. At that trial, your attorney, Mr. Prey, would have been with you, would have cross-examined witnesses and examined the evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, could have asked me to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision after you talked things over with your attorney, and your jury would have been instructed not to consider that decision in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. Do you understand you are giving up all of your trial rights because of the court accepts this resolution? I'm going to go along with the agreement that's on your plea form, and we will not be having a trial. Do you understand those things?
Yes, Your Honor.
Is anyone forcing you or pressuring you into making this decision?
No, sir.
Has anyone made you any promises other than what is written on your plea form?
No, sir.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No, sir.
Do you understand if you are not a United States citizen, entry of this plea would subject you to deportation?
Yes, sir.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this plea could subject you to involuntary civil commitment. Do you understand that?
Yes, sir.
Mr. Prey, is the defense stipulating to a factual basis for purposes of the plea?
Yes, Your Honor.
Court finds it has a factual basis with which the court can accept this plea, finds that Mr. Houts appears to be alert, intelligent. He's had an opportunity to think about this decision and discuss it with his attorney. You satisfied with Mr. Prey's help?
Yes, sir.
Seems like she worked you out a misdemeanor resolution. You've indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. Court will adjudicate you guilty of possessing drug paraphernalia, a first-degree misdemeanor. You're sentenced to 11 months of supervised probation. As a condition of that probation, you're going to be randomly tested for any drugs in your system. You're going to have a drug evaluation. That needs to happen within the first 60 days of your probation. Then you are to successfully complete any recommended treatment. You're going to do 50 hours of community service. That needs to be done at a minimum rate of 7 hours each and every month, starting 60 days from today's date, and every month thereafter until those hours are done. You're also going to owe some court costs.
Court costs of $273, a $15 paraphernalia surcharge, and a $50 PD lien, for a total of $338.
Okay.
Court's going to give you a period of 18 months to make those payments to the clerk of the court collection program. As long as you're making some payments towards your court costs, you'll have no issue with them. If you are unable to pay and they can't find you, they could suspend your driving privileges. Do you understand?
Yes, sir.
You will have 30 days from today's date to appeal the judgment and sentence to the court. If you wish to do so, you must do it in writing. If you can't afford an attorney, one will be appointed for you. Mr. Prey, anything further?
Nothing further, Your Honor.
Mr. Collins, anything further from the state?
Yes, Your Honor. In a negotiated plea in 2020 CF 493, the state will be announcing a no cost of count 1 in exchange to a plea to count 2. I will follow up with an email later today.
All right, I may have announced that this was a plea to count 1. It is a plea to count 2. And Mr. Houts, the state of Florida has followed through with their part of the bargain, dismiss count 1.
What is, I'm sorry, I can barely understand what.
I said the state has followed through with their part of the bargain, dismiss count 1 of the information against you.
Okay.
You entered a plea to the misdemeanor in count 2.
Okay.
Here's 7 days of credit.
We'll give you credit for the 7 days that you served in the jail. Good luck to you, sir. You'll need to report to probation within 24 hours of your release.
Excuse me, sir, am I going to be released today?
Yes, sir. As to this case, 2020 CF 493, you're ordered released.
So I'll be out in a couple hours. Okay, thank you.
Yeah, they got to process you out, but you should be out today.
That's fine. Thank you very much, sir.
Yes, sir. Good luck.
Thank you.
All right, that is the last case that I have on the docket. Ms. Jimenez, Mr. Prey, Mr. Collins, do you have any additional cases that have yet to be
Hey, can you hear me down there? You don't have to run. It's okay.
Hi, Judge Madrigal. How are you?
Good. How are you?
I'm good. Yes, we can hear you and we can see you.
All right. And you are?
Mary Jane Cooper.
Oh, okay. Miss Cooper. Got it.
It's the mask.
Yeah. I know, it's hard to tell with the mask. Yeah, just give me 1 second, okay?
Yep, no problem.
Let's go on mute. Ms. Cooper? So just so you can hear me too, on the re-IAs, I'm going to try to get through those depending on what your position is, okay?
Yes, Your Honor.
Yeah.
And I do have a special request.
Yes, ma'am.
I coordinated with the jail and I was able to go and speak with David Pinero. He's been reset several times. They are placing a Baker Act hold on him. I would like to waive his appearance. I would ask that you appoint the public defender, and I would just ask for a conditional release or a release in his case to custody of Park Place.
Okay, when we get there, just remind me, please.
Yes, Your Honor.
Do we anticipate any probable cause challenges today?
Your Honor, no. There's no probable cause challenges. There is one particular case, the last name is Trowbridge, that I did want to address something with.
Okay.
But outside of that, no. And we have 3 Spanish.
Okay, great. Strobridge, is that what she said? Like Judge Strobridge without it, the S? Oh. Okay. Okay. All right. So let's get the Spanish interpreter on the line before we.
Good afternoon, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn.
All right. How are you?
Very good, Your Honor.
All right. We got IAs, okay?
Very well, thanks.
All right. So let's go on the record. All right. We're here for initial appearances, Osceola County, Florida, on February 10th, 2021. Let's get appearances for the record. We'll start with the state.
Anna Olvera on behalf of the state.
Mary Jane Cooper on behalf of the Public Defender's Office.
Officer Pat Hill on behalf of PTR.
Okay, and I'm Judge Madrigal on behalf of the state, or myself, I guess. So we're going to start with the Spanish interpreters. First case is Manuel Machado, case 2021 CF 397.
Manuel Machado. Primer caso.
John Doe.
It's also AKA John Doe 3149.
1, 2, 3, 4, 1.
Yes, Your Honor.
All right. Good afternoon, sir. Your name and date of birth, please.
Buenas tardes, señor. Se me da su nombre y luego la fecha de nacimiento.
Mayo 9, 69. Machado Manuel.
Manuel Machado, 9 May of 1969.
All right. Mr. Machado, I am going to appoint that young lady sitting next to you in her office to represent you on this matter.
Señor Machado, entonces voy a designar a esa dama que usted ahí ve como representante legal suyo de la Defensoría Pública.
Officer Hill, what's the other legal constraint on this?
He does have a detainer for immigration.
Tiene también una solicitud de retención por el Departamento de Inmigración.
Okay. So, Mr. Machado, I've reviewed the arrest affidavit. I find that there is probable cause for the charge which you are facing, which is possession of a blank forged stolen driver's license or ID card. I'm going to set your bond on that at $500.
Así que ya después de haber revisado el escrito del arresto, determino que hay indicios de culpa por la tenencia de una licencia ilícita. Voy a darle una libertad de fianza, una fianza de $500.
Thank you, Your Honor.
All right. Next.
Gracias, señor.
Do you have another date?
¿Fechas?
Okay, on to me. All right.
La fecha será cuando se le vuelva a avisar.
Next one is Jackson Jimenez Mesa. I'm sorry. Hold on. 1 second, sir. I only had one Spanish, Ms. Cooper. What were the other two you had?
Sorry, I have 5. 2 more said that they need the services of an interpreter as well. So I have Jimenez, then I have Morales Melendez.
Okay. Is it Jackson Jimenez, this gentleman who's there?
Yes, Your Honor.
Okay, good. So,
And then I have Valle Martinez, Garcia Rodriguez, and Ramos Pagan.
let's just take one by one, because, so let's do Mr. Jimenez. So, sir, your name and date of birth, please?
Señor, su nombre y su fecha de nacimiento, por favor.
Jackson Jiménez, 20 de marzo de 2000.
Jackson Jimenez, March the 20th of 2000.
All right, Mr. Jimenez, I'm going to appoint the young lady in her office standing next to you to represent you on this matter.
Así que, señor Jiménez, voy a designar a la dama joven que está allí de la Defensoría Pública para que lo represente legalmente en esta causa.
You have been picked up on an out-of-county warrant out of Seminole County.
A ustedes lo detuvieron porque tenía una orden de detención de otro condado, el condado de Seminole.
The judge has already found probable cause, and they set your bond at $1,500.
Ya el juez había determinado que había indicios de culpabilidad y fijó una fianza de $1,500.
So I will keep it there. We'll let Seminole County know.
Entonces nosotros lo haremos saber al condado de Seminole.
Thank you, sir.
Gracias, señor.
Sorry, what was the next Spanish language one, Ms. Cooper?
Sure, it's Morales Melendez.
Okay, so that's Joey. Is it Joey Morales Melendez?
Yes, Your Honor.
Your Honor, the interpreter is aware that Mr. Jimenez was out of county. However, does he have a case number? Sometimes they do.
I have, it just says B21001009.
Thank you, Your Honor.
We have a different case number, I'm sorry. 20249 CTA from Seminole.
Thank you, Your Honor.
Thank you. All right, the next one is case 2021 MM327. Sir, your name and date of birth, please?
Señor, su nombre y su fecha de nacimiento, por favor.
Joey Morales Meléndez, 6 de septiembre del 89.
89 dijo.
Sí.
Date of birth is September 6th of 1989. Joseph Morales Meléndez.
Mr. Morales, I'm going to appoint the young lady there and her office to represent you on this matter.
Señora, entonces voy a designar a la dama joven que está allí de representante de la Defensoría Pública para que lo represente legalmente en esta causa.
Sí.
Yes.
Sir, you've been charged with 1 count of battery or domestic battery.
Señor, usted tiene un cargo de agresión física, de violencia intrafamiliar.
Another judge has already found probable cause on that.
Ya otro juez halló que habían indicios de culpa por eso.
I have history, Ms. Officer Hill, please.
Yes, Your Honor. He had a failure to appear in 2019.
Antecedentes que tenga, señor Hilton, sí, él tiene un antecedente de incomparecencia a una cita judicial en el 2019.
A no valid DL in January 2020.
También no tiene licencia válida en enero de 2020.
Adjudication was withheld on that.
Y le suspendieron el fallo de culpabilidad en ese cargo.
And he had a driving while license suspended out of the state of Washington in 2014.
Y también en el 2014 tenía un cargo de licencia suspendida de Washington, del estado de Washington.
And he meets the criteria for PTR with bond?
Yes, Your Honor.
All right, so I'm going to do PTR with bond. I'm going to set your bond at $2,500. I'm going to make the conditions of the warrant, adopt those, which are no contact with the victim, maintain separate residence, and not to return to the scene of the incident.
Entonces lo que voy a hacer es que voy a otorgar libertad provisional con pago de fianza. La fianza va a ser de $2,500 con las condiciones de que no tenga contacto con la víctima, la condición de que no vuelva al lugar de los hechos y que esté en residencia separada de donde iba la víctima.
And that is with PTR, Your Honor?
Yes, PTR with bonds.
Thank you.
Y con libertad provisional, su señoría.
And
Sí.
Ms. Cooper, does he need a one-time return?
Yes, Your Honor, he would need a one-time return. And do we have information as to whether or not the alleged victim does want contact? I see that they've been married for 9 years and have 3 children in common.
Y si se le puede permitir que vuelva al lugar una sola vez, si se puede dar esa orden, porque también quiero saber si la víctima ha estado en contacto de alguna manera, porque ellos ya llevan casados 9 años y tienen 3 niños en común.
We had no contact with the victim. We did leave a message, but have not heard back yet.
No hemos tenido contacto con la víctima, sí le damos el mensaje, pero no nos ha regresado la llamada todavía.
Do you have any victims here?
I didn't see any, Your Honor.
Okay.
And, Your Honor, the state would request that the no contact with the victim remain a condition of the pretrial release. If the victim decides at a later date that she does want contact, an appropriate motion can be filed with the...
I don't mean to cut you off. I'm not going to change that. No. But I will allow the one-time return with law enforcement to the residence room.
Sí, le va a permitir que regrese una sola vez en compañía de la fuerza pública a recoger sus cosas.
Thank you, Your Honor.
Thank you.
Gracias, señor.
Next Spanish language one was?
Valle Martinez, first name Joshua.
Sir, this is on case 20 MM2932. Name and date of birth, sir.
Señor, si me da su nombre y luego la fecha de nacimiento, por favor.
12 de octubre del 77.
Sir.
¿Y el nombre?
Yocho Valle Martínez.
Joshua Valles Martinez, born October 12, 1977.
All right, sir. You are. I'm going to appoint the young lady there to represent you on this matter.
Sir, entonces voy a designar a la joven que está ahí para que lo represente legalmente en esta causa.
You are here on a bench warrant.
Usted está aquí por una orden emitida por un juez.
For failure to appear to arraignment.
Por incomparecencia a la cita judicial de lectura de cargos.
So, Judge John Savage set the bond on that warrant at $2,000.
La juez Jan Savage dictó que haya fianza de $2,000.
And that's where it will remain, sir.
Y así así se va a quedar la fianza.
Next court day, February 23rd at 8:15 a.m.
La próxima fecha de comparecencia será el 23 de febrero a las 8:15 de la mañana.
Thank you, sir.
Gracias, señor.
What was the next one?
Garcia Rodriguez, first name Kathleen.
Okay. Afternoon, ma'am. Name and date of birth, please.
Buenas tardes, señora. Si me da su nombre, apellido y fecha de nacimiento, por favor.
Catherine García Rodríguez, 1130-1981.
Catherine García Rodríguez, November 30th, 1980.
All right. Mr. Rodriguez, you are here on a warrant.
Señor Rodríguez, usted está aquí porque tiene una orden de arresto.
On a capias. From Judge Carson.
Emitida por el juez Carson.
So, I am going to appoint the young lady there to be your attorney on this matter.
Así que voy a asignar a la abogada joven que está allí para que la represente en esta causa.
You're facing 2 counts on the capias, possession of cocaine and possession of drug paraphernalia. Judge Carson set your total bond at $1,500 from each count.
Entonces usted tenía los dos cargos, tanto la de tenencia de cocaína como tenencia de adminículos para uso de drogas, y el juez Carson le determinó pago de fianza de $1,500 por cada uno de esos cargos.
Just 500, not 1,500.
500, perdón.
All right. So your total bond is 1,000. I'm going to add conditions, no possession or consumption of alcohol, illegal drugs, or controlled substances.
Así que son $1,000 en total, y como condición le voy a negar que tenga drogas, que consuma alcohol, o también drogas o sustancias ilícitas.
Thank you, ma'am.
Gracias, señor.
Would you like PTR to supervise those conditions, and would you consider drug and alcohol testing?
¿Quiere que el Departamento de Libertad Provisional le haga la supervisión y que le hagan también pruebas de drogas?
Is that an option?
Yes, Your Honor.
All right, yes, sir.
Bueno, sí.
Yes to both, or?
Your Honor, the Public Defender's Office would object a $500 bond on each with the condition of no drugs and alcohol, we believe would be sufficient and would ensure that the client would remain compliant and come to her next court date without having to pay the additional cost of supervision, the additional cost of getting drug tested, and all of that.
Señoría, la Defensoría Pública protesta esa medida de que se le hagan las pruebas de alcohol. Creo que es suficiente con que se le haya impuesto los $500 por cada uno de los cargos. También tiene ya la prohibición de que no consuma alcohol ni drogas, así que ya sería con eso suficiente como para asegurarse que ella vuelve aquí a comparecer otra vez a su fecha del tribunal sin necesidad de cargo adicional.
Okay. I'm going to keep the decision the same. I'm going to have PTR supervise it and manage the drug test.
Voy a decidir que sea Libertad Provisional quien supervise y que también se le impongan las pruebas antidroga.
Next court day, February 17th at 8:30 a.m.
La próxima fecha de comparecencia, el 17 de febrero a las 8:30 de la mañana.
Was there one more?
Your Honor, PTR here in the jail wants to know if you're mandating drug and alcohol testing or just drugs?
I envision just drugs, just drug testing, but no drugs, alcohol, controlled substances.
Sí, nada más prueba antidroga, no alcohol, sino antidroga.
Thank you. Was there one more Spanish language one, Ms. Cooper? No.
Last name is Ramos Pagan, first name Glormar.
All right, this is case 2021 CF 375. Name and date of birth, ma'am.
Señor, si me da su nombre y su fecha de nacimiento, por favor.
Glorimar Ramos, 9/27/87.
All right.
Date of birth, September 27 of 87, Pagan.
I apologize. All right, Ms. Ramos, I am going to appoint the Office of the Public Defender to represent you on this matter.
Bien, señor Ramos, entonces voy a designar a la Oficina de Defensoría Pública para que la represente en este asunto.
You are charged with one count of burglary of an unoccupied vehicle unarmed.
Usted tiene un cargo por entrada ilícita en un vehículo sin haber usado armas y sin haber estado el vehículo ocupado.
Officer Hill, can I get history, please?
¿Me hablo historial, por favor?
Yes, Your Honor. She has multiple priors dating back to 2016. Conviction of drug sales, heroin sales in 2016, petty theft convictions in 2017, multiple petty theft convictions, grand theft conviction. The most recent was a January 2019 petty theft and grand theft, which she was convicted of and sentenced to credit time served. She does meet the criteria for direct PTR upon your discretion.
Sí, su señoría, ella tiene múltiples antecedentes que vienen desde el 2016 por haber tenido venta y tráfico de drogas, de heroína, también hurto de menor cuantía. Eso fue en el 2016. Tiene el hurto de menor cuantía en el 2017. Tiene ella varias penas que se han impuesto por los hurtos de menor cuantía. También tiene un cargo que se le dio crédito por el tiempo cumplido en el 2019 por hurto menor y hurto mayor, y ella sí reúne las condiciones para que se le dé libertad provisional.
I'm going to set her bond. Well, I've reviewed the arrest affidavit. I find that there's probable cause. I'm going to set bond, PTR with bond at $1,000 and condition no drugs, alcohol, controlled substances, or non-prescription drugs.
Entonces, lo que voy a hacer, ya después de haber revisado el escrito de arresto, determino que hay indicios de culpabilidad. Le concedo libertad provisional con el pago de fianza de $1,000 y se le prohíbe también el uso de drogas, sustancias ilegales o de narcóticos que no sean recetados con receta médica.
And Your Honor, the state would be also requesting a no return and no contact with the victim or the witness in this case.
Y también va a pedir que no vuelva al lugar de los hechos y que se le impida que tenga contacto, que se le prohíba, perdón, contacto con la víctima y con el testigo de este caso.
Okay. Ms. Cooper, do you want to be heard on that?
Señor Cooper.
One moment, Your Honor.
Momento, su señoría.
No objection, Your Honor.
Sin protesta, su señoría.
All right, so the court will order no contact with the victim or the witness and no return to the scene.
Así que el tribunal ordenará que no vuelva al lugar de los hechos y prohíbe contacto con la víctima y el testigo.
Thank you, ma'am. Next date.
On demand.
Gracias, señora, y la próxima fecha será cuando se le notifique.
Ms. Cooper, was there any, I think that was all of them, but
That was it, Your Honor.
can you just make sure nobody else needs a Spanish interpreter?
Your Honor, I have asked, there are no hands.
All right, thank you. All right, Mr. Interpreter, thank you.
You're very welcome, Your Honor.
Take care. Let's start back at the top of the pile. I have a Jennifer Espinoza.
And Your Honor, we'd like to waive a reading of the charges.
Okay. All right, I am going to appoint, name and date of birth, please.
Espinoza, 43086.
All right, Ms. Espinoza, I'm going to appoint the Office of the Public Defender to represent you on this matter. I have that Judge Nix Walker has already found probable cause and ordered no bond, so I will keep it that way.
Next court day, February 16th at 9:15 a.m.
Thank you, ma'am. All right, next case I have is Michael Daniel Cedeno. It's case 2015 CF 3743.
Good afternoon, Your Honor.
Afternoon, sir. Your name and your date of birth, please.
Michael Cedeno, March 26, 1996.
Good afternoon, sir. You are here on a bench warrant issued by Judge Tynan. So probable cause has been found, and Judge Tynan set your bond at 0. I will keep it that way.
Next court date.
One more thing. Hold on. I'm going to appoint the Office of the Public Defender to represent you on this matter.
Next court day, February 17th at 8:30 a.m.
Sorry about that.
Thank you, Your Honor.
Thank you. All right. Next one I have is Rayshawn Moiser. Good afternoon, sir. Your name and your date of birth, please.
Rayshawn Moser, May 15, 2002.
Mr. Moiser, I am going to appoint the Office of the Public Defender to represent you on this matter. You are here on a warrant, so a judge has already found probable cause on one count for battery domestic violence. I'm going to set your bond at $10,000. Order no contact with the victim, no return to the scene, and to maintain separate residence. Officer Hill, does he have, is that 2 other cases or 1 other case?
Your Honor, it's 1 other case. His only prior, he's out on direct PTR and case number 20 CF 2901 with the charge of burglary to an unoccupied vehicle, and Judge Young is presiding on that case.
Okay, I'm going to defer to him on that case, so I'll take no action on that case at this time.
Yes, Your
Your
Honor.
Honor, if I may,
Yes.
the defendant is here on a first-degree misdemeanor battery charge. It's a simple battery, touch or strike. A $10,000 bond would be tantamount to no bond for this defendant. Because he doesn't have significant history, him and the alleged victim do not reside together. The location of the arrest was actually his home where he resides with his mother, and he's only 18 years old. I would just ask that a more reasonable bond so that the defendant can get out of jail. Otherwise, he would not be able to get out with a $10,000 bond.
State?
Yes, Your Honor. At this time, the state would request that the $10,000 bond be held, and a motion can be filed with the appropriate judge who's more familiar with these facts of the case.
Give me 1 second. Yeah, I'm going to keep it at 10,000.
Your Honor, $10,000 bond, did you have any conditions?
Yeah, I think I had said them. Yeah. I think I said no contact with the victim and maintain separate residence.
And no return.
Thank you, Your Honor.
I'll take away the no return because it was at his home.
Your Honor.
Okay.
All right. Next one I have is I think it's Ian Cade Patrice. Is it Ian Jade Patrice? Petrie, sorry. Petrie?
I'm sorry, is it Ian Petrie?
I believe.
Ian Petrie?
Ian Petrie?
Yes, sir. How you doing? Good afternoon.
Your name and your date of birth, please?
10/21/1999.
All right, afternoon, sir. I'm going to appoint the Office of the Public Defender to represent you on this matter.
Yes, sir.
You are here for a violation of probation in front of Judge Young. He has already found probable cause on it and set your bond at no bond. So it will remain so.
Next court date, February 22nd at 8:45.
Thank you.
Thank you. I have Juan Jose Medina. Afternoon, sir. Your name and your date of birth?
Juan Medina, 2/8/1993.
Mr. Medina, I'm going to appoint the Office of Public Defender to represent you on this matter. You are here on a warrant from Judge Arendis. So probable cause has already been found. She has set your bond at no bond. It will remain so.
Next court date, February 18th at 8:05 a.m.
Cecil Punter?
Yes, Your Honor.
Afternoon, sir. Your name and your date of birth?
Cecil Punter, 2/4/1982.
All right. Ms. Hunter, you are here on a warrant. Well, I'm going to appoint the Office of the Public Defender to represent you on this matter. You're here on a warrant, an arrest warrant for violation of the domestic injunction. So another judge has already found probable cause. I will set your bond at. Can I get a history, please?
Yes, Your Honor. He has multiple prior batteries, convicted of ag assault with a weapon in 2014, ag battery in 2018, which was dropped, another ag battery 2019, unknown disposition, and he has an open Orange County case, ag assault with a weapon and trespass. He just bonded out of Orange County and was transported here, so this warrant does not violate that bond release. He also has history out of Rhode Island and Virginia.
We'll set your bond at $2,500 or no contact with the victim. No return to the scene and no possession of weapons or firearms.
And Your Honor, the state would also request that the defendant not have any contact with the child that is in question in this case.
It's his child.
It's not a battery, none of that. Sorry.
Hold on, sir. Sir, I just have to remind you, you have the right to remain silent, and that was the prosecutor talking, so they can hear you.
Yes, Your Honor. In case number 20 DR 3503, it seems to be that the defendant was served with an injunction, and the victim actually has temporary custody of their son.
Isn't that my case? I think it is. I'm not going to take action on that, so we'll leave the conditions as they are.
And Your Honor, was there a bond? I heard no contact.
2,500, sorry.
Say that again?
2,500?
Thank you, Your Honor.
Thank you. All right, next one I have is Gregory Trowbridge, I think.
Your Honor, I'm sorry, is the defendant? I understand. Mr. Punter was wondering if the court could give him some kind of guidance as to how he can obtain contact. He wants to continue being a father and having a relationship with his son. I asked him if he has the Talking Parents app. He doesn't know what that is, and I don't know how they go about obtaining that. If you
Sure.
could provide any guidance at all, just to ease his mind.
So, we had an injunction together, sir. I was a judge on that injunction case. So, if you recall, I'm looking at it. I specifically ruled on that case that he was allowed to speak and see the kids. I remember the case now that it's coming back to me. I'm looking at my notes. There was a big discussion about you going to the games, and then she wanted you banned from the stadium, and you said, I'll go to all his games. So in that case, which I'm going to defer to that case, and or a divorce or paternity case should be the ultimate determinative factor, there's no restriction on him seeing the children. However, based on the allegations here, the violation was he went to an address he was not allowed to come within 500 feet of. And then he called the victim. So I'm not giving you legal advice, but the order on the injunction did not ban contact with the children.
Your Honor, I apologize. So just based on what you have just presented to us, the defendant is a little bit confused because he also thought he was allowed to contact his son, and this is the reason why he's here.
That's not the reason he's there. So the violation of the injunction is coming within 500 feet of a certain address. There's a violation, and then the affidavit said that you called the victim, the child's mother, on 2 occasions.
Okay, you have to argue that.
So today is not to adjudicate that as true or false. Merely that's what it says, and that, if it's true, would be a violation. So you can discuss that with the trial court judge, and
yes, Your Honor. Thank you.
Thank you. I remember some cases. I remember most of them. All right. Trowbridge is the next one. I think you had an issue on this one, Miss.
Yes, Your Honor.
All right. So, sir, your name and date of birth, please.
Gregory Trowbridge, 10/24/1989.
All righty. I'm going to appoint the Office of the Public Defender to represent you on this matter, okay?
Thank you, Your Honor. With regard to 20 MM 787, the defendant was actually in custody in Orange County when he failed to appear in Osceola for a court date. Clearly, it was unaware to the attorney that was representing him that he was in custody, also to the court, because they usually do check that. He has been in their custody the entire time. He was even so much as set for a plea date so that he could plea and get out of the custody of Orange since the transport wasn't happening. The plea date was set for March the 5th. I would just ask that Your Honor would grant him a bond if you deem that to be reasonable based on the fact that there was not an actual failure to appear that was willful on his behalf. And he was advised of when his next court date is, which is in March.
State.
Yes, Your Honor. The state would just request that the bond that Judge Yosevich set at zero remain at zero until this is heard in front of her.
Yeah, sir, I understand where you're coming from on this. Judge John Savage had set the bond at 0. It's something that I think can be explained to her, so I'm going to keep it that way. So,
Thanks, Your Honor.
thank you. All right. Next one I have is Emmanuel Williams.
He refused, Your Honor.
I'm sorry?
He refused.
Yes. Okay. All right. Jason Boudreau. Afternoon, sir. Your name and date of birth.
Jason Boudreau, July 5th, 1983.
Mr. Boudreau, you are here for a violation of probation stemming from, looks like Judge Young's courtroom. He's already signed a warrant, so you already found probable cause on the violations of probation and set your bond at no bond.
Next court date, February 22nd at 8:45 a.m.
Ms. Cooper, did I appoint you on that last one? If not, I'm appointing you on that last one.
Okay. Your Honor, a lot of the judges will just say, I'm appointing everyone unless they say they don't want one or they have a private.
This is something somebody could have told me on Monday.
For future reference in the next couple of days.
Yeah.
And Your Honor, just to clarify, that's the Emmanuel Williams?
No, Emmanuel Williams refused. Who we just dealt with was
It was
Jason
Jason
Boudreau.
Boudreau. Mr. Boudreau.
It was a VOP 0 bond, next court date, February 22nd, 8:45.
All right. Next one I have is Jesus David Samuel.
So everyone has been appointed?
Yes. So let's make it. I'm going to appoint the public defender for everybody unless they have retained private counsel already. All right, Mr. Samuel, name and date of birth, please.
Jesus Samuels, 12/24/87.
All right, Mr. Samuel, here for a violation of probation. Judge Karsten, on behalf of Judge Wooten, already found probable cause. Set your bond at no bond. So we'll keep it that way.
Next court date, February 16th at 9:15 a.m.
Yes. Kevin Colon Detress?
Your Honor, he bonded.
You did? Bonded.
Oh.
All right, Lisa Johnson.
She's approaching.
Good afternoon, Your Honor.
All right, afternoon. Name and date of birth, please.
Lisa Johnson, January 29th,
Johnson,
1973.
you are here on 2 counts. First one is petty theft, third or subsequent offense. Second one is causing a minor to be... My glasses are a little foggy. Say, what's that second charge?
Yes, Your Honor, it's a cause to
Causing or contributing to the delinquency of a minor. All right, thank you. All right, Officer Hill, can I get some history?
Yes, Your Honor. She does have multiple priors dating back to 2007. Convicted of a hit and run in 2016, possession of cocaine conviction in 2016. In 2018, she was convicted of a petty theft, contributing to the delinquency of a minor. And then that was followed by a VOP in 2019.
He does qualify for direct PTR?
Yes, Your Honor.
All right. I've reviewed the arrest affidavit. I find that there's probable cause for those charges. I'm going to set your bond at PTR with $100 bond. And no drugs, alcohol, or controlled substances without prescription.
And Your Honor, was that direct PTR or you're doing
$100
bond plus PTR?
Bond plus PTR.
Is that for both counts, Your Honor?
Was it 100 each or 50?
Oh, forgot there was two. So we'll do 50 each.
And Your Honor, could we request a no contact with the minor?
Yeah. Did you hear that, Ms. Cooper?
Your Honor, that's her
My niece.
niece.
It's her niece? Is that what you said?
Yes, Your Honor, and they are together every day. They reside together.
All right, I'll leave it as is.
Your Honor, were there conditions? I'm sorry. I think I missed that.
No drugs, alcohol. Sorry, no drugs, alcohol, or controlled substances without prescription.
Thank you, Your Honor.
Thank you. I got Richard Munoz. Name and date of birth, sir?
Richard Moniu, 5/16/82.
All right, sir, I've already appointed Ms. Cooper there to represent you. You're here on 3 counts, burglary of an unoccupied structure unarmed, criminal mischief, $1,000 or more, and petty theft, third or subsequent offense. I'm going to set your bond on count 1 at $7,000, count 2 at $2,000, count 3 at $2,000. Your total bond is $11,000. And I found probable cause as well. I'm not sure if I had said that or not.
Your Honor, defense is just asking if the court would entertain any lower bond, as 11,000 is tantamount to no bond. He would not be able to bond out.
State?
Would I be able to ask PTR for criminal history?
Yes.
Yes, Your Honor. He has no Florida priors. However, he has multiple priors out of the state of Missouri, Minnesota, California, South Dakota, Wisconsin. He also has an active warrant out of the state of Wisconsin for a violation of probation, non-extraditable. However, the date of the warrant was August 2018.
Your Honor, at this time, the state would request the bond stay, and if the defendant is able to make bond, a no return to the Walgreens.
Yeah, I meant to address the conditions. No returns to Walgreens will be a condition. I'm going to keep the bond as is.
Thank you, Your Honor.
Thank you. All right. Billy D. Williams. Sir, your name and your date of birth, please.
Billy D. Williams, October 18, 1993.
All right. Mr. Williams, you are here for one count of petty theft. I've reviewed the arrest affidavit. I find that there is probable cause for that. I would set your bond at $250, order no return to the scene. Are there any other active cases, officer?
Yes, Your Honor.
State or officer?
He is out on bond out of Orange County for a trespass. He also has an active warrant out of Orange County for a failure to appear on a trespass in which a hold is in place in our system. He has multiple trespass charges, all from 2020.
All right, so then I'll take no action on those. We're going to hold them and transport them to Orange County.
Yes, Your Honor.
Thank you.
Thank you.
All right. I have Peter Weinberg or Winberg. Afternoon, sir. Your name and your date of birth.
Peter Gerard Weinberg Jr., November 13th, 1959.
All right, Mr. Weinberg, you are here on 2 counts. One is marijuana, possession not more than 20 grams. The other one is drug equipment, possession and or using. I've reviewed the arrest affidavit. I do find that there is probable cause for those 2 charges. Officer Hill, a little history, please.
Your Honor, he has older history from 1988 to 2011, which was his last arrest, and he did have a conviction of a duelist in 2011. Early on, it was possession of marijuana and paraphernalia. That was in the early 80s.
I'm going to order direct PTR with the condition of no drugs or controlled substances without a prescription.
Your Honor, would the court entertain an ROR based on the fact that this is a marijuana possession, which I know in Orange County is not even an arrestable offense in
We're not in Orange County.
Orlando, and Osceola as well. This particular offense qualifies for ROR, so I would just ask for an ROR rather than having this man have to pay the cost of supervision for PTR, repeatedly report, and things like that. He doesn't have significant history that I heard. And he's homeless as well, so I don't know how successful he would be at calling, reporting, and maintaining contact. I just don't want to set him up for failure.
Does he have an address? How do we know he's going to show up for court?
Well, Your Honor, we can make sure that he has our contact information so that he can contact us to check in on when his court date is.
So I'll do ROR. Can I put conditions on ROR?
No, Your Honor.
You may, that would just be the condition of the court.
I can put a condition on ROR.
Mm-hmm.
Yeah. His condition is he has to call your office once a week.
Once a week. Okay, Your Honor. Thank you.
Yeah.
And Your Honor, just for clarification, when we do have transients or homeless, we don't have them call in on the automated system where there's a $10 per month fee. We simply have them call their officer once a week to check in. And that way they're notified of their court dates directly from their supervising officer.
Your Honor, I would just like to add, I have had many homeless clients, many indigent clients, and I've never had any that were told that their fee was waived. I just want to put that out there. Instead, their PTR had been revoked for failing to call, for failing to pay, and then they wind up right back in here on zero bond.
We have Senior Officer Hill. Right, Senior? Mm-hmm. So we're all learning. I'm going to keep it the conditions, but thank you for that information.
So, Your Honor, just to clarify, your ROR and the defendant must call the office once a week?
Yeah.
Okay.
I don't know how we're going to enforce that, but they're. I mean, Ms. Cooper, I'm sure will be diligent on informing the court of him meeting that condition. All right, next one I have is Jacqueline Idiscoto. Afternoon, ma'am. Your name and your date of birth, please.
Jacqueline Cotto, 12186.
All right, Ms. Cotto, you're here on two cases. First one is violation of probation. That was an on-view violation. Is the other one this heroin possession? Is that what it is?
It's a violation of probation.
Oh, it's also a violation. Okay. And the second one is also a violation of probation on view. I'll find probable cause on both. I'll hold you. No bond.
Next court date, February 12th at 2 p.m., both cases.
Next one I have is Kathleen Gardner. I think this was a refusal, a medical reset.
Your Your Honor, the only one I have left is Pinero.
Did Kathleen Gardner refuse?
Pardon me?
Kathleen Gardner? That was a
She's in detox, Your Honor. She couldn't come because
she's been reset a couple of times now, right? Yeah, 3 times. Do you, I'll appoint your office, Ms. Cooper. Do you waive her appearance?
Does she have a bond, Your Honor?
She has a bond, but there may be something to talk about.
Your Honor, because she's in...
She qualifies for PTR.
Your Honor, because she's in custody on a simple county ordinance violation, the Public Defender's Office would like to ask for an ROR. She is currently detoxing as well, so she may need some treatment.
I'm going to order PTR. What's the
She
history
is homeless
here?
as well, and this woman was picked up on alleged soliciting. I do have actually a probable cause argument if we are going to argue that one, but I thought since she wasn't going to be here that we weren't doing that.
Well, I don't want to just keep resetting it. It's like,
Sorry?
I don't want to keep resetting it. I mean, if you don't waive her appearance, then we have to reset it.
I understand, Your Honor. I just don't want to set her up for failure and put her on PTR when she won't have the ability to call in, to check in, to make payments for the supervision.
We don't have payments, right?
She is transient, she is homeless. When homeless people are placed on PTR, we do not set them up in the automated system where there's a $10 per month fee. We simply have them call their officer once a week. We just give them a day to call, to check in, and that way we can speak directly to them, make sure they're okay, make sure they're aware of their court dates. Ms. Gardner has minimal history. She has older history from 1987 through 2007. Some drug charges, no convictions. Her last one was a petty theft in 2018, which was adjudication withheld.
This is a county ordinance?
I believe the panhandling charge.
Oh, sorry, she has 2 cases. I apologize.
The county
Is your probable cause argument as to the county ordinance or the felony, please?
The county ordinance, which would give the PC for their search.
Okay. I would ROR her on the county ordinance, please.
So we are waiving her appearance.
Ms.
I can't, I'm sorry, I couldn't hear what you said.
Sorry. So the question was, are we waiving her appearance?
Your Honor, without speaking with her, if it's ROR on all counts, then I would be comfortable with that, but I don't want to do something that she may not consent to.
I would ROR her on the, well, I'm not going to give you an advisory opinion.
Pardon?
I don't want to engage in giving advisory opinions on what I would do.
Oh, I'm sorry. I thought you already said that you
I said I
were
ROR'd on
only
the,
on one, and then the other one was going to be.
the other one I haven't said yet.
Oh, I thought I heard PTR. Sorry.
Yeah. I originally had said PTR on the first count, then I changed it
Oh, okay. All right.
to ROR. And I haven't said anything on the felony case.
Okay.
So do you want to proceed or not?
Your Honor, no. We won't waive her appearance today.
Okay. She didn't waive appearance.
Okay, so reset to tomorrow or?
Yeah.
Yes.
Next one I have is Philip Hayward Harrison, who was also refused. He has 3 cases.
Yes, Your Honor, he refused.
All right. Do you waive his appearance? I appoint you to represent him. Do you waive his appearance?
No, Your Honor. We just asked for him to be reset.
All right, we'll reset it. All right. The next one I think you've spoken to is Mr. Pinero.
Pinero, yes.
Yeah, Pinero. All right, so I'll appoint you on this one. Do you waive his appearance?
Yes, Your Honor. I would like to waive his appearance, and I would just like to ask for him to be released into the custody of Park Place. He is here in the jail. He's been in self-harm since he's been here in the jail. His condition does not seem to be improving whatsoever within this environment. The jail specifically asked me to go down there before we had court today to try to talk to him to get some kind of information so that we could potentially get him out of here. I did go, I got some information. He is transient. I have reason to believe has competency issues. Without an evaluation, obviously, I can't, but there is a Baker Act hold, and if he were to be released by your custody, be released from custody, he would go into the custody of Park Place.
State?
Yes, Your Honor. The state would just be requesting that if defense has competency issue or concerns, that the appropriate motion be filed. At this time, without extensive information, I don't feel comfortable with the defendant being released to Park Place.
Tell me specifically what you're requesting, Ms. Cooper?
Pardon me?
Sorry, can you tell me specifically what you're requesting?
Yes, Your Honor. I'm asking for his release into the care and custody of Park Place so that he can obtain mental health treatment. They haven't even been able to speak with him in a way that makes sense, to be able to determine whether or not he even would meet the criteria for any kind of pretrial release. He's been extremely combative here in the jail, and he is suffering from some kind of mental health situation, and I just leaving him in the custody of the jail.
And I'm sorry, I'm just not, so is that like an ROR with a release, or how, what does it say on the paperwork?
It would be a release, an ROR, and it would be into the custody of Park Place. So then he would go to Park Place, he would have treatment. If they determined that he required a Baker Act, he could potentially be held additional time once that determination is made, but ultimately I believe he's released. He gets 3 days to be stabilized, which if medication is required or anything like that, that would be administered at that time.
Your Honor, if I may just give you a little background.
Get some history, please.
Yes, he does have extensive history dating back to 2002, multiple fugitive arrest, failure to appears. He had an escape in 2017, fugitive in 2018 and 2019. As far as the request for ROR, there is a Baker Act hold. The jail is not able to transport an individual to Park Place while they are in custody, because Park Place is an unsecured facility and we don't have the manpower to sit on him over there. So normally they ROR, and then once he's released, he's taken directly to Park Place. They are able to stabilize him in the majority of the cases on the medication. The jail is limited as to what medication they can dispense at the jail. Because it is a jail environment, they can't really have narcotics, things like that. It's up to the judge's discretion, because many times they'll be sitting in jail and not get the help, the medication that they need. But once they get stabilized, then they're released and they can carry on in more mental function.
And Your Honor, would it be possible to maybe get a pretrial release with mental health conditions, or?
We can't in this situation because of his self-harm status and the current state that he's in. We cannot supervise him.
So even after he is released, or after he's stabilized in a Park Place?
If he went to Park Place, became stabilized, at that time, the judge can determine, and then.
Trial court judge.
Right.
I can't prospectively do it.
Right, exactly.
All right, so I'm gonna send them to Park Place. I'm gonna ROR, I'm sending them to Park Place.
Thank you, Your Honor.
Thank you. That's on both cases. It's the same issue. It's both. All right, Ms. Cooper, the last one I have is Karen Lindsay.
Your Honor, I don't have that name on my list, and I'm going to check with the jail.
Hold on one second.
Lindsay?
Karen Lindsay?
No, it's a Piper, John Christopher.
Oh.
I'm like,
I'm sorry. Karen Lindsay is the person who signed this. He's the officer.
I believe she's been.
She is not in trouble. She is not in trouble. John Christopher Piper.
He refused, Your Honor.
All right. Do you waive?
No, Your Honor.
Okay.
Actually, for him, it's just a VOP. Yes, we would waive his appearance.
All right. So, judge has already found probable cause on the warrant. I would hold him no bond.
Thank you, Your Honor.
Is there anybody else there?
No, Your Honor, that's it.
that should be it.
All right. Thank you, guys.
Thank you. Have a good day.
You too.